Hi, Dirsha. Okay. Yes, I can hear you. Thank you. Can you go to the English channel? Okay. Okay. Thank you, Dirsha. Hi, Aliyah. Are you here in the English channel? Yes, Aliyah. Yes, I can hear you. I think I see that Sophia is still connecting to her audio. Can you please tell her to log off and log in again? Because I cannot do a sound check if her audio is still connecting. Can you send a message to her? No, we're good. Okay, thank you. Thank you. Hello, Lizario. Good morning. I'll test you in the Portuguese channel. Can you speak a few words? Good morning, Lizario. Can you speak in the English channel? Okay, thank you. All right. Lizario, can you ask Douglas and Pascal if they can log in already? Hello, Lizario. Sorry, I just switched to the Portuguese channel. Can you ask your colleagues Douglas and Pascal to log in already? Oh, okay. That's right. Okay. Got it. Thank you. Okay, copy that. Thank you. Hello, Sophia. Can you speak in the Russian channel? Thank you, Sophia. Hi. Can you switch to the English channel? All right. Thank you. Yes, Angelo. Okay. I
Hello, Angela. Angela, can you hear me? Angela, can you hear me? This is the interpreter speaking, Samson.
Hi, Samson. This is Bianca speaking. What
Hi.
language are you?
Chinese. Can you assign me as the Chinese to English interpreter?
Okay, let's wait for Angelo. Hello, Angelo. Are you here?
Hi, this is Gladys. I'll take over.
Okay.
Who are we
Yeah.
testing?
The Chinese interpreter, Angelo has to assign him in the Chinese channel.
Okay, one moment. Hi, Bianca. What's the name again of our Chinese interpreter?
Samson? Samson.
Samson.
Yes.
Got it.
So Gladys, since you're here, I'm already admitting the speakers. So just a roll call. For the 9 to 9:15, Mr. Mong Tuya Altangerel is not yet in. And then VP Bruce Cosper.
All right. We'll
And
wait for.
then Abigail Erickson, I'm not sure if she's going to attend through Zoom or in
She's here.
person.
She's
Okay.
here in
She's
person.
there. All right. So for the first um, 1/4 of our program, the first two speakers, which is Mr. Altangerel and VP Bruce, are not yet in.
Okay. Well noted, Bianca.
Thank
We'll
you.
try to find Mr. Al Tangerel. And then we need to queue in VP Bruce.
Hi, Samson. I'll test you in the Chinese channel. Can you speak a few words? Hello, Samson. And or Kath. Hi, Kathy. Good afternoon. Sorry, good morning. Okay. Yes, I can hear you well. Can you speak in the English channel? Okay, good. Thank you. I'll go next and check with Samson. Samson, are you there? Can you speak in the Chinese channel? Hello, Samson. Okay, thank you, Kathy.
Judge Shah Said from Pakistan is my picture and voice is clear.
Hi, Samson. Are you back? Can you go to the English channel if you're here? Yes, I can hear you. Thank you. Can you go to the Chinese channel? Thank you very much. Good morning, VP Bruce Gosper.
Good morning.
Okay, audio and video is good. Thank you.
Thank you.
जो रेज हैंड करना है वो तो करोगे ना, लेकिन नहीं ना।
as the youngest female politician to be elected in Parliament. The first female to be appointed as Minister of Natural Resources. Served as the solicitor, the highest rated female advisor to government, and held various chair positions in each and internationally. Ms. Rakita, the floor is yours.
I think it's working. Yeah, it's on.
Saying hello. Iya, Zoom ni iya. Iya.
Civil society
Yeah.
ladies and gentlemen, we're not people. It's an honor and privilege to share open remarks today on this conference.
It's muted.
Opportunities like this, where gender-based violence stakeholders across multiple sectors come together with a focus on judicial systems in the Asia-Pacific region.
Chakor sila presentation eh.
A number of Asian Pacific jurisdictions have introduced laws making domestic violence a criminal offense and revisions to criminal codes relating to broader
Kamu dah faham Portugis sila pula.
This means it's going.
legal pathways to justice for survivors of gender violence. This includes the establishment of specific procedures to protect women in the form of protection or restraining orders, legal reforms that remove the requirement for collaboration. Responsive judicial systems. We must work together to ensure gender-based violence survivors access justice across all our respective work areas, whether that is civil society advocacy and service provision, judges, prosecutors, lawyers, government officials, academia, development partners, and I want to acknowledge the importance of active youth engagement in the deliberations. It's not going to be easy. We have to be honest and true to our justice system and the human rights of not only survivors of gender-based violence, but also the perpetrators. Much has been done in judicial and court systems to improve access to justice for survivors of gender-based violence. Some jurisdictions have streamlined court procedures and reduced or waived fees for services like temporary or permanent protection orders, and this is to be commended. All of us engaged in this area understand the complexities and challenges of applying the law to uphold gender equality and women's rights, as well as broader family protection. However, the Pacific region is very complex, and challenges include the need for justice sector reform, limited budgets, and reliance on external professional justice expertise in some of our smaller populated nations. Lack of funding means that systems and infrastructure that support access to justice are not consistently available. Resource constraints affect potential court users and prevents economically disadvantaged people from accessing the formal justice sector. Much research has been done about violence against women and children in the Pacific, and I'm sure many of you are familiar with the grim results. The prevalence of violence against women and girls in all its forms in most countries in the Pacific is higher than the global average of 35%. It is endemic. In Tonga, Samoa, Kiribati, Fiji, and Vanuatu, national research shows the rate of lifetime experience is over 70%. That's double the global average, and is 64% in Solomon Islands. UNFPA's global database on gender-based violence includes 5 Pacific Island nations in the 10 countries in the world with the highest intimate partner violence against women. To link the prevalence rates back to the theme of this forum, I'd like to share data presented to the Papua New Guinea Parliamentary Inquiry in 2021. Only 2% of the approximately 15,000 registered gender-based violence cases were prosecuted. and the 300 prosecuted cases resulted in 100 convictions. That is the scale of the challenge. The COVID-19 pandemic has added more difficulties to accessing justice through border closures, domestic travel restrictions, and curfews or lockdowns. Yet we know from service providers that gender-based violence increased at the same time, in some nations by very significant numbers. Survivors were basically trapped in households with abusive intimate partners or others. Specific judicial strengthening initiative notes that while legal aid for victims of family violence is available in some nations, often by civil society organizations, capacity remains limited. Further, the family protection laws, which have now been enacted in most Pacific Island countries, do not include a right to legal assistance. So what does the gender-responsive judicial system with effective responses to violence against women and girls look like? To answer this, we must acknowledge the challenges or barriers that work against women and girls' effective participation in court processes that involve them as victims or survivors. Pacific Judicial Strengthening Initiative's annual report for 2018 to 2019 was on point, and to quote, patriarchal norms along with a breakdown of matriarchal norms, gender stereotypes, and custom have embedded structural gender discrimination within many Pacific societies. This has eroded avenues for justice, redress, and protection. These barriers allow perpetrators to evade accountability. As a result, women are vulnerable and have little faith in the justice system. Barriers, unquote, barriers to accessing justice for women in Fiji, as identified by the 2017 Fiji Women's Rights Movement report, Balancing the Scales, Improving Fijian Women's Access to Justice, include the physical accessibility of courts for those who live in rural areas, lack of victim support services, lack of integrated and regular analysis of sex desegregated data on cases involving violence against women and girls, cost of accessing the justice system, the sole breadwinner being a mitigating factor in sentencing for rape, lack of information for women living with disabilities on services that are available for them to more effectively access the formal justice system, the need for capacity building in order to improve the delivery of high quality services for women, including training for domestic violence restraining orders and collection and use of forensic evidence. In relation to the judiciary, the same report also makes some key recommendations relating to the collection and publication of relevant data, court procedural and infrastructural reforms to enhance the safe and effective participation of women and children in court processes, and practice direction for sentencing guidelines to address concerns relating to sentencing for sexual offense cases. Then there is the fundamental challenge across the Pacific of the confluence between a person's constitutional rights to justice and the legal system and traditional or customary justice. This Asia-Pacific Conference on Strengthening Formal Justice Systems, Response to Violence Against Women and Girls is timely and a very welcome intervention for Fiji and for the Pacific at large, particularly as the conference is a prelude for more substantive work in Fiji and the region that is geared towards the promotion of gender-responsive judicial systems in the context of violence against women and girls. There's a lot to be done to address these big issues. Much is being done by governments, non-government organizations, and development partners, including SPC, to address the incidence of gender-based violence. We know that when all stakeholders contribute meaningfully, coordinate, collaborate, and innovate to eliminate violence against women and girls, great things can happen. Addressing the barriers identified has begun in many nations with consultative engagement processes, which aims to inform justice sector reforms. The voices of civil society, communities, women and girls are critical in the shaping of these reforms and ensuring that the justice sector is held accountable. Transformative change needs transformative solutions. Reform must be multi-pronged and multi-layered. Capacity strengthening with all stakeholders must result in better, sustainable outcomes for survivors. I wish you all the very best in your deliberations, and my most sincere thanks to ADB and UNDP for this conference and the initiative that will follow Pacific-wide.
Thanks, Ms. Markuka, for highlighting the challenges and for your thought leadership, but also for your inspirational words. Next, I am privileged to introduce our development partner, UNDP's resident representative from Timor-Leste, Ms. Mangtuya Atunjaro. She has rich experience in development spanning many regions, including in Georgia, Kazakhstan, Kyrgyzstan, and New York, as well as working in many key roles in other international organizations. So I hand the floor over to you, Ms. Atunjaro.
Okay, thank you so much. Can you hear me okay?
Yes, go ahead, please.
Okay, great. Thank you very much. Okay, distinguished participants of this international conference, I would like to first of all thank Miriseni Rakuita, Principal Strategic Lead of the Pacific Community, as well as Bruce Gosper, who is the Vice President of Administration and Corporate Management of the Asian Development Bank, Christina Pak, the Principal Counsel of the ADB and the Master of Ceremonies, for their great support and preparation for this regional conference on gender responsive judicial systems. And I also would like to acknowledge all the government partners, development partners, and civil society organizations, legal community, and human rights advocates and academics who are being present and participating in this conference across Asia Pacific, including in the country where I'm serving now, Timor-Leste. First, I would like to highlight how the COVID-19 pandemic really has exacerbated many of the already pre-existing conditions, and including the violence against women and girls, and all the statistics that the predecessor speaker has mentioned. Indeed, many of the girls and women across our region are facing even higher rates of violence and injustice. And this is, again, not something that's new, but it did exist, and it was really entrenched in all facets of our societies, pervasively also present in public and private spheres. And the violence, unfortunately, comes in all forms, including physical, sexual, psychological, and economic. I will not be talking too much about the statistics because I think many of our colleagues will be referring to the statistics and evidence that already exist. But from some of the statistics that I do want to mention is the fact that over 60% of the world's youth now live in the Asia Pacific region. And this is a demographic dividend, and this youth dividend has the potential actually to mobilize the populations of the Asia Pacific countries for significant human development achievements. However, it seems that this potential is not being fully achieved, and there are some factors which are barring women and girls, for example, to fully contribute to their country's development, including due to some pre-existing cultural gender norms and other barriers, some other structural barriers. In the Pacific region, and including in Timor-Leste, up to 68% of women have unfortunately experienced in their lifetime physical or sexual violence at the hands of their intimate partner, which probably also speaks to the issue of societal tolerance towards violence towards women and girls, and this has all kinds of implications across societies, not only on health, but also education, and including also multidimensional poverty. In the Pacific countries and Timor-Leste, girls ages between 10 to 27% of girls are married between the ages 15 to 19 years. And this is another statistic which shows that many girls are, are getting married too early to get to reach their full potential, including pursuing careers and freedoms which they could have been pursuing. So I will not be talking too much about other evidence, but just recently, Timor-Leste has conducted a socioeconomic impact assessment of COVID and the floods. Unfortunately, our country has suffered from the twin shocks of COVID, but also natural disasters. And it shows that actually 80% of the women that we surveyed, they were employed in informal sector. And then due to COVID and the floods, they were the ones who lost the highest number of assets, but also actually carried the highest burden of domestic care and other support, including responsibility of educating children when when the schools were closed and so on. So moving towards what Timor-Leste has done actually in terms of promoting women's empowerment, including women's political, economic empowerment, I would like to mention some of the good work that the government has accomplished with the support of the development partners, including such as UNDP, ADB, and other organizations. Now the government the country has a quota system established. So the women's representation should be up to 30%. And now actually the representation of women in parliament is one of the highest in the world in Timor-Leste at 38%. At the same time, the government has designed a national action plan to counter GBV in close partnership with developing partners. And this is one of the, I would say, milestones that the country is now moving towards to really trying to address the GBV cases as crime as it is stated in the law of the country. But also looking at providing resources to address GBV cases with very much survivor-centered approach. In addition to that, the government has introduced gender-responsive budgeting to integrate gender elements, including also some elements of gender justice in the planning and design of the state budgets. This is very much work in progress, and through our joint United Nations work, such as Integrated National Financing Framework for the SDGs, we are working with Ministry of Finance and Prime Minister's Office to assist with fuller integration and more results-oriented integration of gender-responsive budgeting across all line ministries. So this is one of the aspects that, basically how, if there is laws and if there is quotas, how can we then ensure that actually those commitments are translated into budgetary commitments, but also the implementation modalities and quality of implementation, first of all, across line ministries and at subnational levels. So on a global and regional scale, UNDP as a policy-driven organization is very much committed to promoting and strengthening the rule of law and the protection of human rights. In fact, as was mentioned by the previous speaker, gender inequality does remain as one of the greatest single challenges of human rights around the world. And this was stated by our Secretary General in 2021. And really, it again and again, we emphasize the need for a multidimensional and multi-partner and whole of society approach. So it cannot be just a work or task of, say, gender ministry or a gender department of a government. So there are many partners who have come together, including utilizing the one UN, the UN reform and the one UN approaches. For example, in Timor-Leste, but also in different Asia-Pacific countries, EU-funded Spotlight initiative of the Secretary General has been providing much needed concerted support by drawing various strength and value added and capacities of various UN organizations, but also very much of civil society organizations. And I would really be advocating for this type of multi-partner approach, which really helps us to have that whole of society and whole of partners type of approach. I think perhaps in the interest of time, I would like to maybe stop here, but just a few observations perhaps to think through as we go through this conference. So as I was mentioning in the beginning of my speech, COVID-19 pandemic really has revealed those systemic vulnerabilities, especially for women and low-income households, people with disabilities. However, that great reset that we keep on talking about, after COVID-19, that is yet to be happening, or maybe it is happening, but we really need to, not lose focus and to address and continue advocating for the rights of the most vulnerable. Indeed, right now, the world is experiencing some deep, supply chain and other shocks due to ongoing conflicts around the world, including war in Ukraine. And as many studies now are coming out, these shocks always reach, the most vulnerable communities first, and the countries with a variety of, exposures and vulnerabilities. So this is for us, time not to relax, but really to have that great rethink and, continue working together to advocate for the rights of women and girls. I would like to stop here. At the end of the day, we're talking about rebuilding our social fabric across societies and upholding of social contracts between the governments and the people, and really much emphasizing the rights of the people at heart. Thank you so much for your attention. Over to you, moderator.
Thank you, Ms. Altanjero. Indeed, there's so much to do together, and we're grateful for the collaboration with UNDP. Next, I am delighted to introduce our third speaker, Mr. Bruce Gosper, Vice President of Administration and Corporate Management at the ADB. Basically, VP Gosper takes care of all of us at the ADB, including the Office of the General Counsel, to ensure ADB runs smoothly to support our client countries. This has been no easy task during the COVID pandemic. VP Gosper is also a gender champion at the ADB, and we really appreciate that he has taken his valuable time to join us today. VP Gosper, I'll hand the floor to you. Thank you.
Well, thank you. Honourable Justices, distinguished speakers, respected guests and friends, warm greetings from Manila. I speak after two impressive speakers with very powerful insights on the global pandemic of violence against women and girls. And I'm sure we all appreciate their inspiring words and tremendous dedication. Indeed, violence in all its forms restrains women and girls' rights and opportunities in life globally. No country, culture, or religion is immune. No single factor can explain violence. It is the complex intersection of a range of biological, cultural, social, and political factors, with each reinforcing the other. Changing the trajectory of violence against women and girls requires a multi-sector and multi-pronged approach. It requires coordination and partnerships across international organizations, government agencies, civil society organizations, and individuals, including every one of us. This conference highlights the justice sector and its role. Despite the important advances in international and national laws and policies, violence against women and girls has not significantly diminished. Implementation of laws is still weak. There are capacity and resource constraints, and there are socio-cultural factors. It is widely recognised that greater political will and commitment of resources is required at every level. Supporting gender equality is a top priority at the Asian Development Bank. Gender equality is one of ADB's key operational priorities under our corporate strategy 2030. ADB has mainstreamed gender in our projects and programs, and we've established targets for gender mainstreaming, with at least 75% of our committed projects to be gender inclusive by 2030. Strengthened protection from gender-based violence is also a sub-pillar of Strategy 2030's operational priority 2 on accelerating progress in gender equality. Furthermore, throughout the COVID-19 pandemic, ADB has put greater emphasis on mitigating disproportionate impacts on women and girls and on addressing pervasive gender inequalities such as unpaid care and gender-based violence by strengthening specialised clinics and telephone assistance hotlines for survivors. Moreover, through the ADB Office of the General Counsel's Law and Policy Reform Program, we work with legal and judicial stakeholders to strengthen the formal justice system's responses to violence against women and girls cases to improve their right of access to justice. The obstacles that need to be addressed include gender stereotypes that prevent women from exercising their rights and impede access to effective remedies, complexity and length of proceedings, delays, and gender-insensitive attitudes and practices, and outcomes that result in impunity of offenders. We need to promote survivor-centric approaches. To emphasise, what is required are justice systems that are dynamic and open to innovative, practical measures that are gender-sensitive and which encourage women to use the formal justice system. These outcomes can be substantially achieved through capacity building and training. In the past 2 decades, Asia and the Pacific region has made significant strides in establishing laws, policies, and institutional frameworks, and in providing capacity building training for the justice sector. In 2015, ADB launched a technical assistance program which worked with the judicial system in Pakistan to address gender-based violence cases through capacity training of judges and prosecutors. One significant outcome was the establishment of a model GBV court, where ADB assisted with the drafting of the guidelines and practice notes, advised on the physical setup of the court, and trained the judges. With the leadership of the Pakistan Supreme Court, the model GBV court was replicated in over 100 courts across the country. Building on this great work, last year, ADB launched a new technical assistance entitled The Promotion of Gender-Responsive Judicial Systems, focusing on our Pacific developing member countries and Timor-Leste. Under this new technical assistance, ADB works with judges, magistrates, and prosecutors on developing customised capacity building programs and specialised knowledge resources, as well as exploring special mechanisms for more effective and efficient handling of cases. Furthermore, our work recognises the interplay of personal, situational, and socio-cultural factors. So the technical assistance is supported by a 1 ADB team comprised of representatives from the Office of the General Counsel, the Pacific and Southeast Asian regional departments, and the Gender Equality Thematic Group, along with a dedicated team of experts in law, gender, human rights, behavioural insights, and communications. At the same time, we have convened all of you today, key stakeholders from the formal justice system, civil society, development partners, legal community, and advocates to leverage our collective knowledge, resources, and determination to help eliminate violence against women and girls. I'd like to conclude by thanking all of you for your willingness to come together to exchange experiences and explore solutions. We have a rich program today, and I hope all leave equipped with useful information and connections that will help advance our work together. Bulavinaka to our participants in Fiji, and great thanks to all of you who have tuned in from all over the world. Thank you for your attention.
Thank you, VP Gosper, for your thoughtful words and for your great support for this conference and gender equality at ADB and our client countries. So now we will move to setting the scene to give the audience some background, context, some data, and then we'll move to a short film. So I'd like to introduce two women, two YA women. They're YA women means amazing women, movers and shakers. Samantha Hung, ADB's Chief of Gender Equality Thematic Group, and Abigail Erickson. She's a Senior Advisor of Ending Violence Against Women and Girls at the UN Women. They are here with us. So I'd like to bring them, give them the floor so they could provide some context. Thank you.
Good afternoon, everybody. Thank you, Christina, for the kind introduction. It's a real pleasure to be here with you today in person. So our job for the next 10 minutes or so, although I think we're going to try and make a bit of time, is to provide the context for this conference. And I will start with providing the ADB context, and then I'll hand over to Abby to provide the more substantive context. So if I could just move to the next slide, please. VP Gosper talked about ADB's commitment to gender equality as a whole. And so what I'd like to do very briefly is to give you a bit more detail about how we see it in our policy framework. I know that to the outside world, ADB perhaps might not be seen as a big player in the GBV space, but we do see it as very critical underpinning across all our gender equality work. And I will also then provide some snapshots about how we do that through our operations. On the next slide, please. So as VP Gosper mentioned, accelerating gender equality is one of 7 operational priorities of the Asian Development Bank. So we have that right up in big lights in terms of our corporate policy. And this builds on a long-standing gender development policy since 1998. And where we see it in terms of what we call our OP2, which is operational priority 2, is that we see gender equality under the second pillar as a core part of advancing gender equality and human development. And so it makes specific reference to the need to address protection from gender-based violence. We have a specific corporate results framework indicator. So that's basically the way we report our work to our constituents and our board on an annual basis. And one of the indicators within that is around strengthening protection for gender-based violence. So that's aggregated up at corporate level from project level. In terms of specific language, the kinds of things that are highlighted in our corporate policy are the need to have dedicated components in education and health projects, the need to address women's personal security in a broad range of infrastructure investments, greater work to address project-related risks of sexual exploitation, abuse, and harassment, and also to explore standalone grant and technical assistance projects. And this one on law and justice is an example of that. Next slide, please. So ADB, as many of you know, we invest in a lot of sector work across the board in many different types of sectors. So what we try to do is we integrate consideration of women's safety in that design. And a very good example of that is the way we do our public transport projects. So for example, if we are supporting MRT development or bus system, we would be integrating designs which make sure that the infrastructure is designed in a way to make women feel safe. And so those would be things around helplines on the physical infrastructure, providing safe spaces, including consultations with women around the design of routes. So those are the kinds of very practical things we integrate. I won't go into detail of everything that's on the slide because of time, but this will be made available for participants. But just on the slide there, we've highlighted a couple of specific examples, such as our disaster resilience program, where we had designs around in a post-disaster situation like address gender-based violence. We also in our Kiribati Outer Islands transport. So that's an example of a transport project which has integrated these design features. And also at a more policy level, we are currently supporting through technical assistance the development of some sexual harassment policies in Tonga and Nauru. Next slide, please. So, okay. I think we all know that the COVID pandemic brought along another shadow pandemic in terms of increased rates of gender-based violence. So ADB, we provided very quickly budget support modality to our member governments to help them ride out the response to the pandemic at national level. So there was quite an intentional effort to integrate support, financial support to preserve gender-based violence services during post-pandemic times. And these are just some examples of where that was done. And I specifically highlighted there ones that relate to this region. Next slide, please. And this is just an example of a grant project. Some of our country programs have taken more active programming around gender-based violence, and Mongolia is one of them. And I understand we have some people dialing in from Mongolia here today. So we've had quite active since 2019, a grant project specifically on strengthening the quality and access to services to domestic violence. And that's been around shelters, also economic programs, and also really helping to finance the evidence base and study. And in response to the COVID crisis, we also boosted that through additional financing, particularly around making sure that helplines were much more available and not interrupted, and also the media around that. And I think that's my last slide, which is, if you could move on, bringing it back down to here. So this was, I'm sure we talked about, and a lot of the people that were involved in this original project, technical assistance project, which was a precursor to this one, really has been very innovative, and it's a very important space, the work we're doing in the legal space, because of the real merit of it and the real need for it, but also because it helps inform our broader programming and policy engagement in countries by learning about what we can support in the legal space to make sure that we have a better justice response to GBV. So with that, apologies for the very quick broad brush, but I'm trying to maintain time. I'll hand over to Abby. Thank you.
Good afternoon, everyone. I was just handed a note to say be extra brief. And so summarizing the issue of violence against women and girls in the Asia Pacific region is already in 5 minutes very difficult. So I am really going to be my verbose self and try to hit the key points. Next slide, please. I won't spend a lot of time on the statistics. We know that gender discrimination and gender inequality is driving violence against women and girls across the world. 1 in 3 women have experienced physical or sexual violence by an intimate partner or sexual violence by a non-partner. 1 in 5 girls worldwide have experienced sexual abuse in childhood. And we know that violence is not one thing happening here and one thing happening there, but it's happening over the lifetime. I do think what's important to note at the global level, and we'll bring it down to the Pacific level, is that we've got huge rates of violence globally. And look at this. Less than 10% of survivors seek help from the police. Why? What is driving that? Next slide, please. Asia Pacific region, I think Marasani and many of you as experts in this room, experts online, know that we have some of the highest rates of violence against women and girls. The Pacific region in particular, as Marasani said, is 2 times the global average. Generally speaking, if you were to summarize the data that we have, and look, we have a lot of data. We have proved the problem of violence in this region. We need to prove the solutions, and we really need to prove the solutions in the justice sector. Next slide, please. Next. Obviously, we know, we can say here, COVID has exacerbated violence. When you look across all the countries in the region, helpline calls have increased. Some of that is existing violence that was exacerbated by lockdown, and some of it, of course, was new violence. I think what's interesting to look at, we don't often talk about this, is what men are reporting. The prevalence data that we have in the region is on women's experiences of violence, and that is already so high. As Marasani said, 68% of women in Kiribati and other countries here in this region reporting. Yet we still know that's underreporting. What are men saying? There was a survey that was done in 2013, 6 countries. What did that find? Bangladesh, Cambodia, China, Indonesia, Papua New Guinea, Bougainville, and Sri Lanka. At least 1 in 4 men surveyed said that they had either been physically or sexually violent against a female partner. at least 1 in 10 said they had raped a woman or girl. Next slide, please. Why? What was the motivation that men gave for sexual violence? The most common reported motivation for perpetrating rape across this study was related to men's sense of sexual entitlement or fun or bored. We hear a lot that alcohol is driving violence. That is not true. It is gender inequality. It's men's perception and belief of their power over women and girls and over women and girls' bodies that is driving this violence. Next slide, please. What were the legal consequences in this study? What did we find? Men are reporting quite a bit of rape. The majority of men who admitted to perpetrating rape did not experience any legal consequences. Next slide, please. Sorry, I'm not more uplifting. I just want to give a really serious picture of the issue of the context of this issue. Recent research out of Kiribati, 2019. In essence, it was baseline for prevention intervention, but for the most part, replicated the 2008 survey in Kiribati, looking at both women's experiences of violence and men's perpetration. Largely speaking, the rates of violence hadn't changed. It was still hovering around that same overall lifetime average of 68%. But what you're looking at here is women's responses and men's responses. You can see that men's responses, men's sharing the violence that they had perpetrated is higher than what women are saying. What does that tell us? Again, the shame, the fear, the stigma of reporting is still driving underreporting of violence from women. And really the normalization, the social norms that this is just what happens is giving you a much clearer picture. Next slide, please. What do we know about help-seeking behavior? This is a real problem, right, across the region. High rates of violence against women and girls, and yet women and girls are not experiencing the full breadth of help that they need. In Vanuatu, 98% of women experiencing violence did not access the formal justice system. We see high rates, 70%, 89% of women who say they have experienced violence never sought help. Yes, they might have told a friend, they might have told a family member, but they never went in for help. Why? Next slide, please. Sometimes the violence wasn't considered serious enough. Not understanding, not knowing about the justice system, lack of awareness of services, the embarrassment, shame, fear of not being believed, fear of losing her relationship or children. Next slide, please. I think it's important because this is framing the context. I know I have to go quickly, just a couple of more points on access to justice, because access to justice and women feeling that when they go in and they report a case first to the police and that her story and her experiences can be taken through in a gender sensitive way, that is not what women are experiencing. This is driving why they're not seeking access to justice. What are some of the barriers? Well, we have pervasive gender discriminatory attitudes socially across all parts of society, and that is showing up in the justice sector across the board, from starting with the police all the way through. The trial of rape that was just, I think it was released in 2017, looking at criminal justice responses of rape in Thailand and Vietnam. You were raped because of the way you dressed. If not by this offender, you would have been abused by somebody else. That's just an example of the discriminatory attitudes and norms that women experience in the justice system. Next slide, please. There's research that we have, and Morrison has already acknowledged it, from the Fiji Women's Rights Movement, also research coming out of Vanuatu, and I want to also acknowledge Diva for Equality's 2019 research, Unjust, Unequal, Unstoppable in Fiji. What is some of this data telling us? Practical obstacles, costs, distance, complexity of court processes, limited knowledge and limited access to information about rights for women and girls, about how to access care. All of this is driving forward low levels of access to justice. In the DIVA research, 76% of lesbian, bisexual, trans women and gender nonconforming responders who have been sexually assaulted do not feel safe going to the police. So these issues are compounded for people who are identifying as LBT or gender nonconforming, women and girls with disabilities. Next slide, please. I'll be very brief here. I think we're going to go into recommendations. What do we need to do? We need to look at the gender discriminatory attitudes that are preventing women and girls from having a positive experience, a safe experience, and a fair experience in the justice system. We need to strengthen access to quality, essential services. We need to ensure that women and girls know where and how to get help. There's some awesome work that's happening in the Pacific, awesome work, I'm sure, around the region. I don't want to discount that, but there is a lot of work that we still need to do. And I look very much forward to hearing more from the participants in this conference about what is happening. And I will stop there. Thank you.
It's really hard to do justice to, it's just so much information. But just building on, what Abby said about all the awesome work that's happening. And indeed, there's been a lot of awesome work happening in Timor, despite the challenges and despite the bad statistics. So we'd like to wrap up this opening session by sharing a inspirational video about a survivor's experience through the formal justice system. And we are really grateful to the courageous Nana Maria Abrantes for her willingness to share her poignant and inspirational journey with us. Here's a video, and hopefully that shows that what the formal justice system can do for a survivor. Thank you.
Nessa feito primeiro, how no pai sempre amanhã how nunca hakar serviço, how estuda de e how no tempo escola ne how matene. Jadi how senti kata how Morrison de ulu how ski kuang ne furak tebes how ela lehan. Tama ia tempo no how no pai how mai mas Morrison dia. Ambo tutu bami la falta. Nebe ba ma escola amnara acompanha malo, how nessa ne acompanha malo lit. How fear los kata nia mak sideline da nebe ke i how ne me. I line da nebe ke. Sila halo kane kau ya ikus. Husine baqueiras, mactome 14 anos, 14 tahun ami hela amutuk ne. Laia feliz total até a data. Sira bah falling how. Wanhir sira ba prenda ser lori hana falling ba. Ni família for falling how. Então ida ne takati how ni ibu. Taka how ni ibu hal how ni espiritu mateng. Hal how ni espiritu mate how senti kata hana fuang ne mate how sa ima mate. Trauma ne comece madai to na basira. How sempre hanuring basira. Kanu hari apa tama mai maklano. Imoto tu bakotuk o imoto tu tamba quarto to manonok dia. Atau nune apa kita hirus ini. Husi kama makia we. How polisi, how serviço unik by a fating de investigação. E how investiga do único caso ainda na arrancada violência doméstica. E a tinha em 2009 ou 2010, wanhira quando ia na campanha o siri de feto e o women será a campanha quando a lei violência doméstica. Hawa nessa coco atu estuda, habuka tuir. Lei ni makida hanusa, lei ni mahaker kona basera seda. How taris tam how foi hatete mania dan kata enough is enough. Holia foi how hatete kata how malakuena. Ida ni han sa fano na how, han sa batida kumes tuku how makaso na diang Anda harus bangkit. Oteng hadir. Haba defensor publik ya balidi, habuka de advogado. Hada wensa kana wato hana keisa. Hawa rumah hana faktus ya lorong 5 ne larang. Cada horas, cada minuto ni bemak ni halo violência bahau hau kerek. Ni bakuti hau hotu hau hari sa fasti oi hau kerek sere mako ini halo bahau. Ni tolok hau kerek. Ni tuk hau hene be hau kerek, data horas hau kerek. Entang hau fiarang katak, se hau kuliah hau baseia balei mak tribunal mas label fosal hau se karek hau dia indane violência. Husi uluk hau polícia, hau tene katak ia enjau barak, enjau lokal barak, lili foco pers pradet, e dire koni papel, mas bisiramos ia safe room. Hanessa polícia, e a polícia vulnerável person unidade da nebe maka khusus ou especialidade ni investiga quando crime e violência serni. Julgamento ba ia ketia ser bolu labarik seratu husu. Amne wan seratu husu se di sistema tuirse. Hototo hili hau. Hoto tatete kata mi tuirama. Haula interesse ni osangida, haula interesse ni fosmu sangida, hawa karakter ni husik hau. Hawa karakter hau sai tu si linha dani, linha violência ne. Ikus hau manan. Hau manan, o inhira kan martelo baku, dala tolu. Hau merik, hau kuang hane pai hau tanis. Hana pai ba ke ba besa kiri tuirau. Ho tu la berani tuirau. Tabane sirate tere kata decisão da beka somo família. Hau bidu husi escada leteng husi tribunal, hau bidu tu torai, hau filho mai hanu uma. Surga, rumah adalah surga. Tama hau senti kata livre duni, contente. Hau tatete kata fetan bema contente liho munu kalmak hau, ya tempo ne ba. Tamba hau tina sanulu racing hat, hau nunca tu contente dah nesane.
Thank you so much for this beautiful film. We're grateful to Mana Maria for sharing this story. And her husband actually was very supportive of sharing her story widely as well. And a great thanks to our producer Samar there and her film and production team in Timor-Leste for this beautiful, beautiful, inspirational story of what the justice system can do. So we will conclude now with the opening session. Thanks for all your patience. And we're over time. So really appreciate your patience. But we'll take a 10-minute break. Sorry, it's not the 15 minutes, but short 10 minutes break, and we'll come back for the plenary sessions in 10 minutes. Thank you. Please get up and stretch. Thanks. Okay, is everyone up for a group photo after all that sitting? Maybe we could, a quick one? Would that be okay? Okay, great. Just a quick group photo. Yeah, because we're going to do one after dinner. But maybe some stretching, some yoga. Okay.
Oh, excuse me. And we just like to ask everybody to come up to the stage so we can take the group photo.
Yeah. Okay.
Morrison.
Hello. 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 Yes.
Hel- Hello, Tatun Translator 2. Can you send me a chat? This is Bianca.
It's on translator too. Access is off translator now.
Okay, hold on.
Yeah. Test two. Test. Hey. Yeah. Two.
Setting. Setting here. Audio setting. No.
Okay.
Yeah.
Testing.
Yeah. So. No. Okay. Wait. So what is it?
Check. Two. Mic check. 1 2. 1 2 1 2. Check. Testing 1 2. 1 2. 1 2. Testing 1 2. Mic check. Yeah. Okay. Set.
حول ولا قوة
Hey everyone. Well, now it's really loud. We'll start soon. I'll talk a little bit away. The sound is too good now. Thank you. So I think we're just queuing up our virtual audience. I think we gave them a minute or two to reconvene, and we'll commence. Thank you. We're a bit rusty being in front of a live audience in this new hybrid world, but it's really great to leverage more participants around the world. So we just have to get better at it. Excellent. So just let me know when we're live and we've joined our virtual audience, please. Are we on? Excellent, excellent. All right, well, welcome back, everyone. That was a very exciting opening ceremony. We are a bit behind time. We'll try to make it up, but we'll still proceed with the allotted time of 1 hour and 15 minutes for this plenary session. So welcome, everyone, to plenary session 1. Our first technical session. It's entitled Addressing Gender-Based Violence in the Formal Justice System, Regional and International Perspectives. And it'll be moderated by Zari Zana Abdul Aziz. We warmly call her as Zari. So she's an internationally renowned gender and human rights lawyer and an adjunct professor at George Washington University, as well as ADB's expert on the gender responsive judicial systems technical assistance. So I'd like to also do a quick intro to our amazing panelists from 6 countries to share their international and regional experiences. And live on stage with us is Miliana Tari. She's the legal service manager of the Fiji Women's Crisis Center, who's been just really doing incredible work for a very long time. And so we're really pleased to have her. And we also have 5 excellent panelists linked in from Zoom from diverse regions of the world. So we have the Honorable Justice Mansour Ali Shah from the Supreme Court of Pakistan. And we've heard about the incredible work that was done in Pakistan with respect to the gender-based violence courts. And he was one of the key responsible parties for helping to establish the GVV courts in Pakistan. We also have Genoveva Tisheva. She's a CEDAW expert and the director of Bulgarian Gender Research Foundation and chair of the Bulgarian Alliance for Protection Against Domestic Violence and Other Forms of GVB. She's a very eminent gender expert internationally. So we're really, really grateful to have her. We also have Commissioner Andi Yatirani from the Indonesian National Commission for Eradication of Violence Against Women. So we are so pleased to have Ms. Andi. We also have Tavita Sarulumi from PNG. He's linking in from joining us from the Pacific Justice Sector Program. And finally, we have Emily Morrison with the Sustainable Solutions Timor-Leste. So again, this will last 1 hour and 15 minutes and in the form of a moderated panel discussion. So I will hand this over to Zari.
Thank you, Christina. Good morning, honorable justices, distinguished guests, ladies and gentlemen. As Christina said, we have 5 exciting and eminent panelists this afternoon, 4 of whom are zooming in, and Miliana, who's with us today. This session is on identifying gaps, barriers, and solutions to achieve fair and effective protection of women and girls in the formal justice system. It is to ensure victims' dignity in the legal judicial process. It is to provide effective protection measures to minimize repercussions and remove fear. And it also aims to talk about reparation, which is the least developed, to rebuild lives post-violence. We have 1 hour and 15 minutes, more or less. Let me quickly go through the format. I will ask each panelist a question, and each panelist will have 2 to 3 minutes to answer the question. And I would like to request the panelists to keep time so that everyone has the opportunity to contribute. Questions from the audience will be answered at the end of the contributions. For participants through Zoom, you may post your questions in the chat box. For audience in this hall, you may use the microphones. Please state to whom you're addressing the question, if relevant. The moderator, Laura Gutierrez, a lawyer from Colombia, will be helping us to manage the Zoom chat. Well, let's begin. And since Miliana, you're here and we are in Fiji, I'll start with you. Let's talk about the situation in Fiji. Now, we all know the good work FWCC has done and in FWCC's interaction with victims and survivors. What have you assessed to be the factors that have stopped women accessing the formal justice system? And what has motivated women to access the formal justice system? You have 3 minutes, thank you.
Thank you, Zari. So in terms of barrier, first and foremost, we've noticed that it's when women are unaware of their rights, as well as the law and the services which are available to them to reach out for help or for support. On top of that, there's also the barrier of insensitive attitudes from those in the formal justice system. Rape myths and the gender stereotyping being used in terms of questioning and comments during cases, not giving enough consideration to the power dynamics that exists in the violence against women and girls field. Then there's also the attitudes of society as well. Our society is very patriarchal in nature. So that's actually one of the main barriers to that we've noticed. Then there's victimization. The survivors themselves are further victimized when they do decide to reach out and access the formal justice sector. There's also the shaming and the blaming of survivors when they choose to access the formal justice sector. Ostracization and stigma as well. Then there's also the normalizing of tolerance of behavior, violence in society as well, as well as interpretation of religious texts. There's also delay in justice as well. Survivors tend to feel that that is one of the barriers. Their cases take too long to conclude, and investigations usually take forever for the police to actually lay charges on the perpetrators. So for Fiji Women's Crisis Center, our counselor advocates would have to go and advocate at the police station, call and do follow-ups with the police officers. And now we've had to hire a police liaison officer as well to do that job for us. Then there's also the attitude and laxity of service providers who are involved in the formal justice sector. For example, in terms of enforcement of DVROs, the police, they take too long to serve the DVROs, domestic violence restraining orders. Then there are the service providers who do not know or understand the law or what the law actually mandates them to do. So they don't understand that part as well. Then there's also service providers who are unaware of the national service delivery protocols which are in place to make things easier. We've also had survivors who have faced challenges in accessing legal aid. During COVID, Legal Aid moved their services to an online platform. So most of our survivors indicated that it was very hard for them to actually access a lawyer because they do not have resources or data or money. Then there's also women being turned away from the registry as well. When they would like to go in and file their applications at the court registry, they're turned away from there as well. Because the court clerks who are dealing with them, the registry staff, they would feel that the applications that are being filed are either vexatious or frivolous, and this never goes to the magistrates. This is just at the registry itself. Then there's also the issue of not enough being done to ensure the safety of survivors after they have reported, perpetrators being bailed out, and there's no consideration, no adequate consideration in terms of the relationships that they have, that there's a domestic violence relationship that happens and what would happen if the perpetrator is being released on bail as well. Okay. So all in all, it's actually just, because of all these reasons, the survivors feel that they don't have enough confidence in accessing the formal justice system.
Those are a lot of issues. I'll move on now to Mr. Tavita Seriulumi. All right. Am I muted? Sorry. I'll move on now to Mr. Tavita Siriulumi. Tavita, are you there? Yes. Tavita, thank you for joining us. Tavita, a victim survivor's decision to access the formal justice system is influenced by many factors, not least of all, as we've heard, her treatment in court and the outcome of the proceedings. Okay. Tavita, is the justice system able to protect the victim survivor's dignity in this regard?
Thank you, Zari. I'll just, within my 2 minutes, just answer the question in twofold. Is the current justice system able to protect victims as it is? The answer is yes. I think starting from the police, interactions with victims are critical. While police officers in the Pacific have been trained on domestic violence response, for the most places it's still limited to a handful of officers who are specialized to respond to to violence against women. This does not mean that other officers can't respond, but what it means is that there are a number of officers who are able to respond to victims in a manner that ensures that they are protected under the law, and those officers are very limited. I think also sensitive approaches to victims that take into account the dynamics of violence can enforce protection of victims. Moving on from the police, it should be reiterated across the justice system to understand why there is a focus on violence against women. Effective response from the justice system has to appreciate why laws have been repealed, amended, introduced, and for example, why protection orders, as raised by FWCC for domestic violence, was created, just as one example. Issue of protection orders in a swiftly manner and emphasizing that breach of orders is viewed as a serious criminal offense ensures that victims who access the justice system can experience some form of protection or sense of justice. Second part to the answer to my answer is, can the justice system be able to protect victims better? The answer to that is a definitive yes, and more work should be focused on this. In my response earlier, I was talking about one element, which is the police response. However, lawyers, prosecutors, as well as the judiciary need to be trained and informed on the specifics of violence against women, gender, and women's rights. As explained by FWCC earlier, victim blaming and stereotypical attitudes remain across the justice system. Lastly, I just want to talk about lenient approaches towards offenders of domestic violence is an ongoing issue in the Pacific. Domestic violence continues to be viewed as a minor offense, despite all the lobbying and advocacy to criminalize the behavior. While more deterrent punishments are issued for sexual offenses, more needs to be done, I think, to address domestic violence as a serious criminal behavior. Often such views, as viewing domestic violence as a serious criminal offense, often such views are reserved until a woman is murdered from domestic violence, and then there is an uproar from the public, from the police, and even the judiciary. So still a lot of work is required to improve the justice system for victims and how it responds to offenders.
Thank you, Tavita. I'll move on to Justice Mansour, Shah. Justice Mansour, we've just heard about the problems, the barriers that women face while accessing justice. I'd like to talk about the role of the Supreme Court, and in particular, one of your decisions, Justice Mansour, the decision of Atif Zarif. It was delivered in 2020 and it really caused a stir. It was a good decision. And what was important, it made the treatment of a victim survivor of sexual violence no less a constitutional issue, and in which you referred to human dignity. Can you elaborate on why the decision emphasized on the humanness and human worth of a victim survivor? Over to you, Justice.
Thank you. Good morning, Zari. Good morning, Christina, and good morning to everybody in Fiji. It's very early morning in Lahore. And let me just qualify at the very beginning that I might just leave the conference after an hour because I have to rush to court, but I'm here for an hour with you. Thank you for the question. Atif Zarif case is just another case which deals with rape. And in this case, the victim was considered to be somebody who was a working class woman, who was more fashionable, perhaps in her area. And she was very liberal, so-called, and she had friends, and they thought this was a pretext that she could have been raped, you see. What was very important was that we thought this is the time that we push back the two myths that were surrounding this area, that any woman, these gendered notions, these social cultural notions, expectations that are attached to women in this regard led to two things. That if you were to look at this past sexual history, look at her character, two myths were generated, that she could have certainly consented to this arrangement, or secondly, that her statement would not be reliable. We thought these two myths had to be demolished, and had to be demolished well. And we thought the best way is to go back to the Constitution, and it gave us a chance to look at the Constitution with this gendered justice sense, a justice lens, you see. And we looked at the Constitution once again, and we thought that, and when we went through the fundamental rights, which are the constitutional human rights provided under the Constitution of Pakistan, there is no distinction between man and woman, you see. All the rights are available to both of them. In fact, the Constitution goes ahead and gives affirmative action in support of women, and perhaps, and we thought that the reason behind this was not biological. It was not because there was a man and a woman, but because we thought that the society was so, the founders of the Constitution thought that the society was so patriarchal in nature, and these gendered nuances were so deeply embedded that women had to be protected, and we have to bring it back till we break this glass ceiling. So I think the Constitution provided all that. And right to dignity, we thought, was the right to be used in this case to push back these two myths, and also to announce that gender has no place in a courtroom. We have to decide matters on evidence and not because of these expectations that the society builds around sexes, you see. So we thought right to dignity, which is perhaps the only right in the Constitution, which is non-negotiable. It is not subject to any law. And it provides that you cannot take away the basic humanness of anybody. And we thought by taking away the independence, the identity, the autonomy, and the free choice of a woman, we were taking away her dignity. And by imposing or by bringing in the right to dignity, we pushed back these two myths. And the judgment actually really announces that past sexual history, character of a woman, past character of woman has nothing to do with deciding the case of rape, which could be based only and only solely on the evidence that is produced before the court. And we thought this could only be pushed back by bringing in the right to dignity, and any reliance on gender and these social expectations would affect the humanness of a person and the human worth of a person. And I thought, and the bench thought at that time, that the best way to introduce and announce this would be through the right to dignity, one of the strongest and perhaps the only right in the Constitution which is non-negotiable.
Thank you so much. And indeed, the decision was groundbreaking. And thank you, Justice Mansour, for joining us so early in the morning from Pakistan. I'm going to move now to Ms. Genoveva Tisheva, who's joining us from New York. Good evening, Ms. Tisheva. Ms. Tisheva, who is a CEDAW committee member. Ms. Tisheva, are you there? Is she there? Genoveva?
Yeah. Yes, sorry, she's having issues. Yes, there she is.
Hello, hello.
Yeah.
Yeah, Genoveva,
Hello.
we're dealing.
Hello.
Hello, welcome. Thank you for joining us from New York. It's
Can you
a
hear
nightmare
me
for
now?
you. Yes, we can. You all right?
Yes.
Okay.
Yes.
Ms.
Thank you. Thank you very much. I will turn now the video in order to be able to respect the time, and because I'm not sure if everything will be okay from so many distances. So, so thank you very much, Zarizana. Thank you, you all organizers and supporters of this very important conference, Asia Pacific Conference on Promotion of Gender Responsive Judicial System. I would like, as a CEDAW committee member, to present the concerning this very specific issue, the response of the
judicial system in cases of gender-based violence. So the CEDAW Convention, first of all, to say all of you know, but to remind that it's the main source of universal standards concerning women's rights and women's dignity, women's autonomy, economic independence, issues that you mentioned here several times, and so important also for the theme of the conference, and also women's empowerment, including through clear obligations of the state obligations of due diligence, and also to mention for achieving substantive equality, but also for combating gender stereotyping. The convention being ratified by 189 countries has a strong focus on the elimination of and protection against violence against women globally. So from that point of view, the committee has been systematically addressing the position and treatment of victims, survivors of violence against women in the criminal and civil proceedings, and insisting on enhanced protection by the state parties for ensuring victim safety and dignity, and in order to achieve compliance with state obligations, as I mentioned, and due diligence obligations under this convention and other international standards. And through its main method of work, the dialogues with the state parties, the committee makes recommendations under Article 2, the core obligations of the state, for example, to adopt appropriate legislation, to ensure implementation of legislation and policy, to guarantee access to justice for women, and without gender stereotyping by the judiciary, law enforcement, and other institutions, to modify and repeal discriminatory laws and practices. It is also through the monitoring under Article 5 of the Convention on Gender Stereotyping and Prohibition of Gender-Based Violence that also the committee pursues this end. And also the article on equality before the law, among others. There is a special general recommendations 33 on access to justice for women, very important, and also general recommendation 35, as you know, which is updating general recommendation 19 on gender-based violence against women. They're applicable, and the committee addresses these important issues also in its views and recommendations under the communication procedure of the optional protocol to the convention. So here are some examples of recommendations and issues related to the theme we are discussing now for the rights of victims of gender-based violence in the proceedings. Strengthen the judicial system, including through additional financial, technical, and specialized human resources, with a view to handling cases in a timely, gender-sensitive, and non-discriminatory manner, and ensure that all cases of gender-based violence against women are promptly and effectively investigated. This is from the concluding observations, for example, from Botswana, but it's an issue that's systematically monitored. Can you hear me?
Yes, Genevieve, maybe you can slow down. If you, we can hear you, but if you could slow down, it would be better. Thank you.
Okay.
And maybe, Genevieve, can I
I'm giving examples from different countries, not only from the region, because I decided that it's important to see that it's everywhere, because you are discussing also issues from the region where the conference is taking place, but I think it's important. So similarly, in a case of communication against Denmark, so the state is reminded about its obligation to ensure that women are protected against discrimination committed by the judiciary and by public authorities. Very important, because this discrimination amounts to gender-based violence sometimes perpetrated by the state. Another important problem I would like to highlight related to the position of women victims in the proceedings and their intimidation is related to their children, to the fear for losing their children. And I think it's very important to remind an important recommendation of the committee here: the rights or claims of perpetrators or alleged perpetrators during and after judicial proceedings, including with respect to property, privacy, child custody, access, contact, and visitation, should be determined in the light of women's and children's human rights to life and physical, sexual, and psychological integrity, and guided by the principle of the best interest of the child. This is a recommendation maintained in General Recommendation 35 and based on several cases, recommendations in several cases before the committee, communications, Gökçe versus Austria, González Carreño versus Spain,
the case I mentioned against Denmark, and Jallo versus Bulgaria. I think it's very important also to discuss this specific aspect and challenge for women during the proceeding. And also it's important to, I think you touched upon that in the previous panelist speeches, but there is need for addressing specifically credibility and weight to be given to women's voices, arguments, and testimony. This is a recommendation specifically from GI versus Finland, because otherwise, the committee says, there is difficulty proving any kind of illegal act against the woman and her children. In other cases also it was mentioned. So it's important also emphasizing that perpetrators' rights cannot supersede women's human rights to life and to physical and mental integrity. Gökçe versus Austria. And this is during the whole proceedings, this risk assessment actually, that all the institutions should prioritize. Also give priority to criminal prosecution over reconciliation or mediation in the criminal proceedings. This is from the recommendations and concluding observations on Lithuania. And also provide victims of gender-based violence with safe and prompt access to justice, including free legal aid where necessary, very important, and also to ensure access to effective and sufficient remedies and rehabilitation, also during the proceedings. It's based on the cases SL versus Bulgaria and Promolex versus Moldova, and it's in line with the general recommendation on access to justice number 33 that I mentioned. Also,
Thank
it's
you so
very
much,
important.
Thank you so much, Genoveva. Certainly all those cases, will be posting that in the post-conference booklet. And if you can share with us those cases. Would you like to wrap up, Genoveva, in 1 minute, perhaps?
Also would like to give some examples of very recent, actually. I would like to give some example from, for example, the concluding observation to Kiribati from March 2020, for example, because it was mentioned in the introduction, to say that to ensure safe spaces for women victims of gender-based violence and domestic violence, and that I think it's very important. And also here is, as it was mentioned, we recommend to a large extent to eliminate myths existing around sexual violence and the fact that women have to behave in dignity and discipline, for example, and that it comes in the adjudication of sexual violence cases sometimes, and to discontinue these practices. And this was also recommended to countries like Maldives, but also to the Seychelles. I think it's important that we recommend it also to give the opportunity through the new communication channels for women to be acquainted, women and girls to be acquainted with their rights during the procedures. So yes, and if yet about the vulnerable groups, maybe to say or something that.
Okay, thank you so much, Genoveva. We certainly will circulate all those cases and the good work that the CEDAW committee has been doing. I'd like now to move to Commissioner Andi Yentrani. Commissioner Andi.
Yes, Kajari.
Hello.
Yes,
thank you for joining us. Andi, we know Komnas Perempuan, which you are chairing, has been working towards establishing an integrated criminal justice system for handling cases of violence. And there's been Supreme Court guidelines, and just 2 weeks ago, the anti-sexual violence law was passed. And I have to congratulate you, this has been a long fight. Can you please share with us some of the measures Komnas Perempuan had identified to ensure dignity of the victim survivor during the legal judicial process, and do these reforms incorporate international standards? We've heard from Genoveva Tisheva. Do these reforms incorporate international standards? To you, Andi.
Thank you, Kak Zari, for the question, and also thank you for the committee for having me in this panel so that I can have the opportunity to introduce one of the works of Komnas Perempuan, or Indonesian National Commission on Violence Against Women, a national human rights institution, which is debated in the CEDAW committee. regarding our status. And we are focusing on the elimination of all forms of violence against women. According to our presidential decree to the establishment of Komnas Perempuan, we are mandated to specifically refer to CEDAW and also Anti-Torture Convention in our framework. Kak Zari and other distinguished guests, you may be aware of the May 1998 tragedy, which is the background of the establishment of Komnas Perempuan. So in this tragedy, which is like around 24 years ago, sexual assaults, particularly rape, are committed against women during the riots targeting the Chinese community. It is also the tragedy that raised the awareness of the public on violence against women. And in response, numerous women crisis centers were established throughout the country. So Komnas Perempuan works closely with these service providers, women crisis centers, and we also consolidate lessons learned from the experience working with the victims for policy advocacy to enhance the victims' access to justice and recovery. Whilst listening to the first speaker and the second speaker, Kak Zari, I found a lot of similarity to the situation in Fiji and the Pacific with the barrier faced by the women victims of violence, particularly sexual violence in Indonesia. And based on that experience, as mentioned, we then introduced the concept of integrated criminal justice system in handling the cases of violence against women. And the concept, in a nutshell, actually promotes better fulfillment of the victims' rights as being discussed and also promoted at international fora, and also better coordination amongst particularly criminal justice institutions in handling the cases. In the concept, the acknowledgement and awareness of all service providers and law enforcers to uphold human rights, particularly victims and survivors' dignity during or throughout the legal judicial process is central. And there are at least 5 measures that we endorse in this concept. Firstly is the recognition of the important role of counselor and psychological support for victims or survivors throughout the judicial process. This support is particularly needed by the women survivors of sexual violence who are facing not only the unfamiliar justice process, but mostly hostile responses to their cases. So psychological support is one of the key for them to be able to go throughout the judicial process. Secondly, the measure is actually to have a clear guideline for law enforcers in investigation, prosecution, and the trial in questioning victims or survivors, or even women defendants in order to uphold their dignity, including the prohibition to refer to women's sexual history as justification to the act of violence or to stereotyping that may derogate their position on the case. The guidelines should govern the provision of needed support by the women victims or defendant in order for them to comprehend and to be able to participate substantively in the judicial process, including the fulfillment of the rights to legal aid, to information, and for those with disability, for the court to provide decent accommodation in the judicial process. And we also endorse that the guideline needs to be accompanied with adequate mechanism, a monitoring mechanism as a constructive tool to continuously strengthen the implementation of the guideline. The third measure is to have an effective protection for women victims or survivors, which include the protection from retaliation from the perpetrators and also repercussion, including in relation to the usage of social media nowadays, which is very threatening for women victims. The fourth measure is to have an optimal multidimensional support for victims and survivors to rebuild their life, including to have economic independence and social acceptance. And lastly, a better mechanism to prevent recidivism and also the reoccurrence of the violence in general. So we are very encouraged in the last 5 years, as you mentioned, Kak Jari, the concept of integrated criminal justice system has gained more and more support. The Supreme Court back in 2017 has issued the guideline for the judges in trying cases of women before the law. We also have similar guidelines by the High Prosecutor's Office in 2021, and just recently, the 5 measures are adopted in the anti-sexual violence law that just been signed by the president on the 12th of May, which is like 10 days ago. There are some encouraging detailed measures in this anti-sexual crime law, which is necessary to strengthen the integrated criminal justice system, including the protection of victims of online sexual violence, as I mentioned, prohibition to sue on defamation allegation against victims or those reporting cases of sexual violence, and the prerequisite for law enforcers to be trained specifically in investigation of sexual violence with human rights and gender perspective. So all of this is expected to eliminate also culture of denial and blaming the victims. Due to the limited time, I'll stop here and also expect to have like a future opportunity to discuss more at length on this anti-sexual crime law. Over to you, Kak Zari.
Thank you, Andy, and congratulations on these milestones. Very quickly, Andy, are there still gaps in ensuring victim survivors' dignity that concern you? If you can just talk to this very quickly in about 1.5 minutes. Thank you.
Yes, Kak Jari, whilst we are encouraged with the progress in the recognition of the survivors' dignity and human rights, the implementation is actually very worrisome, particularly to the limited infrastructure to ensure the implementation. During the pandemic, for instance, we have observed the spike of report cases of violence against women, and we are expecting that the number of reports will be increasing by the issuance of, in response to the issuance of this anti-sexual violence law. Last year, 2021, there are an increase of 72% of sexual violence cases reported directly to Komnas Perempuan only. In the same time, during the pandemic, services for women victims are still mostly relied on institutions run by the civil society, particularly the women's group, who have a very limited resources, and they found themselves, I think I can call it burned out during the pandemic time, not only because they are facing the increasing number of reported cases, but also they have to face the health situation themselves, and also the burden of domestic chores they have to do due to the COVID-19 mobility limitation policy. The service provided by the government is still reported to be very formalistic, and many regions are not equipped with knowledgeable and skillful officers. We are also concerned the police to date do not have the clear guideline, unlike those of Supreme Court and High Prosecutor's Office, so that they can investigate violence against women in order to ensure better access for women to seek justice. The unit to handle gender-based cases is also very inadequate and thus needed to be strengthened. We have the promise of the National Police Chief about a year ago to increase the unit status to become a specific directorate in order to allow more resources to be allocated, but the implementation of this direction is still yet to be seen. And we also endorse the prosecutor office to have specific task force or unit to handle the gender-based violence, because there are a lot of cases reported to Komnas Perempuan where the evidence is go back and forth between the prosecution office and the police. And lastly, if I can just mention that we are also aware that the service to terminate unwanted pregnancy due to rape or other sexual assault is rarely available in the country, despite the fact that the service is actually guaranteed by the law. So with this condition, the victims are enforced to bear the unwanted pregnancy. And there were even some cases where the victims are then criminalized because they're taking abortion. So we believe that this situation may hinder the victims from enjoying their dignity because they have to keep on facing derogation due to their unwanted child, or even being criminalized for having the abortion, which is actually a right according to Indonesian law.
Thank you so much, Andy. Thank you. I'm going to move now to Ms. Emily Morrison.
Hi, Gary.
Hi, Emily. Hi. Thank you for joining us. You're calling from Darwin, I believe.
That's right.
Yeah. And Emily, how can the courts play a positive role in protecting victim survivors?
Yeah, I think we've heard a lot from examples around the world, and particularly from Andy and also from in Indonesia, also from Pakistan, about having really clear guidelines. And I think that's something that's really important that can help to guide the judges, the prosecutors and the defenders in how they represent victim survivors in court and how they interview and work with people. And I apologize that my video is not working today. So I think there's also, we've heard a little bit about having victim-centered approaches, and sometimes it's easy to talk about those things and really difficult to think about, well, what does that look like in practice? And I think that was a great example from Andy. Having counselors and having that assistance and psychosocial support throughout the process is really important. Having clear guidelines for the police, for the justice sector, so that there's some clear procedures in place that can also be monitored. There were a lot of mentions earlier in the sessions about the justice system itself being built on fairly patriarchal systems and attitudes and values. And so I think the moves towards victim-centered approaches are quite encouraging, and having more representation of victim survivors in any reforms or in any changes that are being made. So there are examples of victim survivor associations and advisory councils that are increasingly getting strengthened around the globe, and ensuring that they have a voice in how the justice system works, how the peripheral supports work around that with social assistance, with economic assistance. It is a really important step in making sure that responses are based on the needs and the rights of victim survivors, not just on trying to make a system shift a little bit when there are some fundamental issues within that system itself.
Thank you, Emily. Emily, I'd like to quickly turn now to reparation. What do you think are the immediate, short, long, medium-term support for victim survivors so that they can access justice?
Yeah, there are some challenges with reparations. As you know, in the Timor-Leste context, where fines are given, and then that raises the concerns of retaliation and retribution against the victim survivor and her family. So we need to be really cautious when we think about things like reparations, that we're doing it from the perspective of the victim survivor and what's needed for her, and that might be on a case-by-case basis. I think the Indonesian model of having a general fund that's available to support the recovery of the women is a really great approach that doesn't rely on a direct relationship with the perpetrator. It's between the state, the justice sector, and the victim survivor, and sends quite a strong message that it's incumbent on the state to support victim survivors and that we hold a social responsibility towards that.
Thank you, Emily. Mr. Tavita, on the same note, Mr. Tavita, you've been doing work on domestic violence and women's social economic dependence on the accused. As we know, this serves as a barrier to survivors accessing the justice system. Can you share with us your work on addressing this barrier?
Okay. In relation to the Pacific, like many societies around the world, is patriarchal. Majority of men as a collective enjoy all the privileges, power, access to decision-making and resources. Women and many victims, on the other hand, have access to so much less despite the amount of work they do. And as mentioned earlier, they still experience violence. I think just in the context of the Pacific, as mentioned by UN Women, the high rates of violence against women in the Pacific is worsened when considering the geography of Pacific countries, remoteness, isolation, and limited availability of government services as well as infrastructure. These factors greatly impact the court's response to domestic violence. It is important that the justice system, other agencies and organizations to realize the current trends in sentencing for domestic violence offenders, the challenges, and work on a solution that is contextual to the reality that most women will return and continue to reside or cohabit with the offender, her partner, because they just don't have any else to go or the resources to live. A way to address, and one of the things we've done here, a way to address and work towards increasing protection of victims post access to justice is to create carefully designed programming that addresses the men's violent behavior while ensuring that continued support is provided to the woman. Perpetrator programming is a gap in the Pacific region, and I know we're talking about support to victims, but I'll make the linkages as I speak. Perpetrator programming is definitely a gap in the region, but if carefully designed and if it has a good monitoring system and prioritizes women's safety, it can be one of the solutions in improving women's safety post access to justice. It can also form part of the restitution that so many victims often unable to access or enjoy with the current programming and justice response that we have currently. However, having said that, it's, a lot of caution is also needed in this area of work and working on what has already any programming that supports men's violent behavior, specifically for domestic violence. It should be based on a feminist critique of power relations. It must have various mechanisms to address the risk of collusion with the program and the offenders, as well as mechanisms to monitor behavior change. Also critical to these types of programming is that it should have a component which is voluntary and not mandatory for victims, but a voluntary component that allows and ensures that wives are supported and continue to receive empowerment, whether through financial literacy programs, economic programs, ongoing counseling and support, those things. So to provide such restitution to victims would only be possible if domestic violence perpetrator programs are implemented where there are strong women's groups that have a clear understanding and analysis of men's violence against women. And lastly, it is important that these programs should exist as part of a justice system, as part of the formal response, and not operate independent from the formal criminal justice system.
Thank you so much, Mr. Tevita. It's very interesting work that you're doing in PNG. On the same note, Justice Mansour Shah.
Yes.
I'd like to link the question of reparation and attrition as it happens in Pakistan. This is a critical issue. And in fact, one of the reasons for attrition is the prevalent practice of the accused paying compensation to the victim survivors, which results in the victim survivors or the victim survivors' family withdrawing, women resiling, recanting. Is there provision for the court to order compensation? And if so, is this regularly done?
Thank you for that question. I think it's a very important question, and I think we need more innovation jurisprudentially in this area. Even though, as far as the law is concerned, yes, there is fine provided with the sentencing provision. There is also a compensation provided under Section 544A of our Criminal Procedure Code. But yes, I think this is absolutely important that we start adding this compensation, this rehabilitation aspect when we are addressing rape cases or other cases of GBV, as to how do we rehabilitate the victim and what steps could be taken. The law gives a lot of margin. The law provides that compensation which is adequate must be given. I think this area is untouched, and I think this conference, and thanks to this question, this opens up a host of new ideas that need to be brought in. I think compensation needs to look at her employment needs, her economic loss, a number of other psychological and mental trauma that she might have gone through needs to be compensated. And to my mind, it need not be monetary. See, we can monetize the overall activity, certainly. But I think there could be steps that could help her rehabilitate, maybe get her back on her employment, or maybe an apology or a public guarantee saying that that it will not be repeated. Number of things could take place, but so far our law talks about compensation, and we do provide compensation, but I think that's not adequate. We need to go beyond that, and we need to start structuring compensation, and that would depend on a case to case, certainly, and we need to see what is the nature of the trauma that the person has gone through. We need to take evidence on that account, and I think when we're coming up with sentencing and talking about compensation, we need to consider the factual position and see what could be the best tailored compensation for that case. And I think this opens windows and doors for fresh jurisprudence in this regard. And I thank you for this question and this conference for opening the issue of reparation, which has just been so far dealt with a mere compensation, a monetary compensation on the side. It does not address it as a whole subject or a sub-subject within the sentencing policy, which is, I think, absolutely critical. And I think courts of the other countries also, and in my country, we will certainly be looking at compensation more holistically, where we think we can rehab or restore or restitute in the best possible manner that we could do. I think that is what the underlying purpose of compensation is, and it is not just monetary amount given to the victim. Yes.
Yeah. Thank you so much, Justice Mansour Shah. And indeed, I mean, we love to see, looking forward to compensation, reparation being more integrated into the legal judicial justice system, so that, you know, that women can rebuild their lives post-violence. Now, moving forward, I'd like to end with you, Miliana, since we started with you. The Fiji Women's Crisis Center, it has undertaken a lot of advocating on correcting systemic issues and legal reform. Can you share with us how successful has this been, and what are the lessons learned from legal reform initiatives? Over to you.
Thank you. So for us at the Crisis Center, you know, continuous and consistent lobbying and advocacy for better laws has been one of the strategies that we've been using. We've been part of the movement that had advocated for the Domestic Violence Act to come into place, the Family Law Act, no drop policies, and legally, I mean, the legal recognition of de facto as, you know, under the law, de facto relationships. There's also, in terms of advocating and holding other stakeholders accountable when it comes to gender stereotyping and rape myths, because the Crisis Center, at the Crisis Center, we've heard gender, you know, the rape myths and gender stereotyping being used 30 years ago, and still now it still creeps in and we hear about it. So as soon as we hear about it, we talk about it, we raise awareness on it, and we hold stakeholders accountable for that as well. This is not just for the bench and the judges and the magistrates, it's also for other stakeholders such as the police as well. There's also in terms of advocacy, we also carry out submissions to the parliamentary standing committees when it comes to laws proposed laws that would impact women's lives and rights. Then there's also being part of the National Action Plan against violence against women and girls. And we're also part of that technical working group, and we're the preferred VOG trainer for that. So for this would actually be something that we say would be a very successful thing for us, because for the past 38 years, we have been consistently saying that, you know, patriarchy, unequal gender power relations happens to be the root cause of violence against women and girls. And now we actually have a government document in place, the NAP, that recognizes this. So that part of our advocacy has been successful. We've also, you know, taken into account the National Service Delivery Protocol as well. We played a significant role in that because of our experience in working with women who are survivors of gender-based violence, as well as their experiences in accessing justice system as well. In addition to that, part of our advocacy also includes development of resource kits and training of frontline workers as well, especially in times of disaster and online violence. There's also training of other service providers and gender sensitization, and holding interagency meetings as well. In this way, we're able to hold meetings with the police executives, talk about the challenges that women are facing, survivors are facing in accessing the police services, and discussing strategies on the way to move forward in terms of better service delivery. The same is also done for other stakeholders as well. Then there's also the advocacy in terms of working in collaboration with other stakeholders. We work with the NGO Coalition on Human Rights, the CSO Alliance. Then there's also, in terms of our regional work, we have a network on the Pacific, network against violence against women. And in this network, we are the secretariat for that. So most of our work there, we're able to mentor members in the Pacific and, work with them in terms of advocating for law reforms in their regions. And we also conduct regional training programs as well. And all of this goes towards our work in the region. So in terms of whether we see how successful it is, we've noticed that it is successful. The work is there, though there are some insensitivities that we would see creep up, but for us, it's all about advocacy. The more that we raise awareness on it, that's how we address those issues.
Thank you so much. It would seem that everyone just underlines the importance of using gender analysis in strengthening the legal system, the legal judicial system. Just say that? Yeah. Okay, with that, I'd like to conclude this part and open the room to question and answer. Can we have some questions?
Sorry, we have 4 questions on the chat. If you want, we can start there.
Yes, please. Laura?
Of course. Since Justice Mansour has to leave, maybe we can start with a question that's for him. And the question reads like this. Congratulations on the key precedents in Pakistan where the victim's sexual history cannot be considered in court. Our questions relate to how is this jurisprudence rule trickling down to the lower courts to secure the small courts in rural areas? Will they follow the path of the Supreme Court? Do you have any specific strategies in that direction? And are there any consequences if a judge fails to follow this jurisprudence besides an appeal?
Thank you so much for that question. Well, once the Supreme Court decides in our country, it becomes the law, and all the courts subordinate to the Supreme Court are supposed to follow it. So there's no question of not following the judgment. So I think Atif Zarif sets the precedent, and not only on the fact that we've demolished the 2 myths, but what's more important is the directions are also issued to the medical officers that they cannot introduce the 2-finger test anymore, or they can't use terms like habitual and all that. This is out of the medical literature. And since then, we've been noticing that the medical reports that have been coming before us in the courts do not mention the 2-finger test anymore, or the fact that the woman was habitual or had any sexual history. So I think the judgment has started showing effect, and the executive as well as the subordinate judiciary, they have been following it. The other question that also is important, that the Supreme Court has also come up with a judgment saying that this majority of our GBV cases arise out of honor killing, which the law says no. I mean, there's no defense and no exception as far as honor is concerned, but people used to bring it under grave and sudden provocation, saying that we saw our wife in a compromising position, and that because this is a question of honor, and that sort of I was out of control, and there was a sudden and grave provocation, and I killed her. That too is changing, you see, and we're saying that grave and sudden provocation that's related to honor killing is no grave and sudden provocation. I'm sorry, the culture where you think of a woman as your chattel or as your property, and you feel that the honor seems to be affected, and something sort of you get possessed, and you could take her life, is no answer anymore. And such cultural values have no place in the legal system. So grave and sudden provocation based on honor killing would also have no place in our jurisprudence anymore. So that is another, I just wanted to add, is another feat. that we're heading towards. So yes, answering the question, once the judgment comes out of the Supreme Court, it's followed, and I think it's being followed. And as I said, we've noticed some medical reports totally changing the way that they report on sexual the offense. So I think yes, the effect has taken root and it has gone down effectively.
Thank you, Justice Mansour Shah. There is a question in Tatun. Gladys, can we have the Tatun translator on? There's a question here in Tatun. If there are any questions from the floor,
yes,
we can take two.
Sorry, it's just the same question, but it's just translated. They are saying that on the chat. The question was already answered.
Oh, okay.
And there is another question for Justice Mansour related to the previous one. And it says, for a gender-responsive judicial system, is it important to have male judges to proceed over gender-based violence cases along with women judges? Or does having a woman judge help only in meting out justice to women?
Thank you for that question. No, I think it has to be both. We have to have both sexes as judges. We've got extensive training done in Pakistan. As I said earlier, we need to have a gender-neutral mindset for a judge sitting in a court. Gender has no place in a courtroom, to my mind. We decide cases on the basis of law and the evidence before us. So I think, yes, we are training our men, we are training our male judges as well as our female judges, and collectively they need to take this on. It cannot be just divided and matters left to the female judges alone. I think they both need to do it together, and our training has helped, and I thank ADB on that account, where we've had an extensive training program for our judges on gender sensitization. So I think we are heading in the right direction, as long as, and the jurisprudence coming down from the Supreme Court is also helping. And I think there'll be a time soon that we sort of break this glass ceiling and we understand that these gender nuances cannot have any place in a court of law.
Thank you, Justice Mansour Shah. I think we'll take a question for Ms. Miliana. A question for you. Within the Fijian context, do you consider that there is a need for a specialist court to address gender-based violence?
Yes, there's actually a great need. There's actually a great need for specialized court to deal with gender-based violence, because it would mean that cases would move faster, it would be determined faster, and women would not have to wait for long for their cases to reach an end. They would not need to keep coming to the courts every time their cases are being called. Specialized court would also mean that there would be specialized training for the magistrates or the judges who would be sitting in those courts, as well as specialized trainings for the court clerks that would be dealing in those cases, as well as the registry staff who would be dealing with survivors who would be coming to the registry as well. So there is a great need for specialized court for GBV. Yes.
Thank you, Milana. There is a question here for Commissioner Andi.
Yes, Zari, I have read the
Thank you,
question
Andi.
as well, and I'll
Andi,
take
there's a question for you. Oh my goodness. I don't know whether you're familiar with this. It's from Justice Pasang Wangmo. Is it correct to assume, okay, you have to know what's happening basically, that Johnny Depp cannot then file case against actor Amber if the similar anti-sexual crime law exists in the US?
Yes, Zari, and I think it linked to Daniel Fatt's questions regarding the part of prohibition to protect the victims from being sued by the alleged perpetrator from defamation. Actually, this is a quite common practice in Indonesia, where the alleged perpetrators then file a case against the victims, claiming the victims' report are a false accusation. And it is, as asked by Justice Pasang Makuno, raised quite a debate during the discussion of the bill. I mean, like, both camps have the argument and would like to ensure the principle of non-discrimination and also fair trial and justice for all parties. But according to our experience working with the victims, the threat to sue the victims, combined with the information on the problems to gather evidence for sexual violence case in particular, which in many cases actually require the presence of the other witness, which is not available. And then gender bias in the law officers and possible corruption, particularly when the perpetrators are much better off than the victims at the societal level. So with all of this situation, in many cases, it actually stopped the threat to sue the victims, actually stopped the victims from reporting the case or from participating in their judicial process. Hence, with this knowledge of the situation, the parliament decided to pass the article to protect the victims from being sued for defamation. And in the same time, the perpetrators still have the rights for what we call in Indonesia, rehabilitation of good names or reputation in the aftermath of the trial, should the court decided that there is no ground of evidence to pass any statement against the perpetrators. I stop there, but if I can add more on restitution, Kak Zari, I think one of the very encouraging breakthroughs from this anti-sexual crime is actually the introduction for the right to be forgotten for the victim's sake on online platform, and to ensure the confidentiality of victims' identity in the court decision that make for public. And then the court was asked to also put into the decision the access to needed support, including health and psychosocial support post-trial. Before this law, actually in Indonesia, we have what we call victims and witness protection that also regulate restitution. But less than 20% of the court decision regarding restitution were carried out. So in this new law, the court was actually authorized to confiscate and conduct an auction of the perpetrator's property to pay the restitution. And it is mandated for the state to ensure the amount of restitution is met. If it is not met, then the state have the obligation to provide compensation. And for this purpose, the state will establish kind of a victims fund. However, since this is a very new regulation, a new law, we still need to see the implementation. But within 3 years, the government is asked to provide reports to the parliament. So within these 3 years, we are expecting to have better improvement of the infrastructure in general.
Thank you so much. The new law is quite comprehensive. I mean, these are new issues, and the defamation, I mean, it's been happening, but for the law to address these issues, the right to be forgotten, violence on the social media and the internet, I think we all are still grappling and working on these issues, and particularly with the involvement, not only of the state, but of big corporations who are involved and who are actually in the position to do something about it. And how do we hold those transnational corporations accountable, apart from the state? So with that, thank you so much. Oh, great. We have one question from the floor.
Thanks very much. Mine is actually, the first part is related to the issue of compensation and reparations, and where would those where we've seen that working, because we know how hard it's been for us in climate change to get loss and damage fund finances in place, the facilities in place. So if that's the case, is this really an option? Is it something that could be, you know, a real future that we could look forward to? And in what kinds of contexts is that possible? That's the first one. And then the second is around this issue of, you know, no one left behind. What about LGBTQI people, about lesbian, bisexual, transgender women, transgender men, and gender non-binary people? Here in the Pacific, for instance, we have, you know, non-binary liminal spaces that we can talk about twin spirit people. We can talk about issues of Fa'afafine and Fa'atama and many other indigenous identities. So I don't hear a lot of that discussion in kind of legal spaces. And I really would love to know if we're any further forward, if anyone on this panel, it's been really fascinating, but I really haven't heard anything about sexual orientation, gender identity and expression and sex characteristics. And it's a really important set of work to take forward in terms of judicial practice, in terms of the state systems of justice. Thanks.
Thank you so much. Is there any panelists who would like to answer these questions?
Yeah, could I just take a go at it? I think it's, even though most of our cases in Pakistan are structured around binary sexual orientation, but I take the question. I think the LGBT area is something that's very important. We have dealt with transgenders by providing them recognition, giving them voting rights and their recognition in the national registration card. Yes, to me, the same literature and same ethos applies to all other genders also. So yes, irrespective of the sexuality, the principle remains the same, that the matters have to be decided strictly in accordance with law. So yes, even though current status is at a binary level as far as Pakistan is concerned, but I think the principles could easily sort of move beyond that and address other areas if the cases come before us. And quickly, if Zari, if you allow me, I see a question on the chat from Judge Nusrat Ali Siddiqui, I think. Could I answer that? Is that allowed? Yes. So
Please
I
do.
think the question is that during the trial, should there be a psychological expert or other experts available to assess the nature of the trauma so that the compensation could be worked? I think it's an excellent question. I think the entire sentencing policy needs to be seen. We don't really have a sentencing policy in Pakistan. I think it's high time that we make a distinction between conviction itself and then the sentencing part of it. The sentencing part requires complete evidence on its own and a complete understanding on how do we go about sentencing. So compensation forms part of that sentencing domain. So first of all, we need to conceptually be clear that for sentencing, we need to have a separate set of proceedings. Once we do that, then within that, the compensation issue would come up. We'll have experts. We'll look at what are the ways of rehabilitating a person, what are the ways of restituting the victim. So it cannot be just rushed the way we rush it right now. We have, with the conviction, we have a sentence, add on to the conviction. That's not the way it's going to handle. That's not the way forward. The way forward would be that after conviction, sentencing needs a little more attention and more evidence needs to be brought in. So yes, the question is well taken. I think we need to have experts. We need to spend some time on compensation and come up with innovations in compensation. That's how we need to go about it. Thank you so much.
Thank you so much. Just to bring the context to the Pacific, Tavita, if you can quickly address the question of the compensation in a minute or so.
I'll just follow through with what everyone has been saying. I think in the Pacific, it's quite similar. How issues around restitution and compensation still is done within a patriarchal setting, and despite well intentions from a court, even though it's victim-centered, we are sending women out. A lot of this is happening within patriarchal settings where everyone is benefiting. Within the context of the Pacific countries I've worked in, a lot of the things around compensation that's done outside of what's court-mandated, and even some that's done within the context of court-mandated compensation, it's about the benefit of everyone else except the victim. So that's something, yeah, so that's just something to bear in mind as well. And just very quickly, I just want to also just address what Nolin said about training law and justice response in this area. Nolin, just from a police perspective, we've started training the police around sensitivities towards people from different sexual gender identities. We'd also try and take into context countries which still criminalize the behavior. What we try and do with the police is work with the police in countries where, for example, here in PNG, even though it's a criminalized behavior, we tell them why not to use it and why not to use that. And why even those provisions, it's very difficult to prosecute a case because both parties are willing. So that's something we are doing now. It's not comprehensive. I think the next step is involving people like you and groups like you and expertise in that area to be involved in police training and to help us be sensitized a bit better. Zari,
Thank you
there's
so
a
much.
question. Sorry, there's a question there on perpetrator. Do you want me to answer it very quickly?
Yes, if you can answer quickly in half a minute or so.
Yeah, okay. Just the issues around perpetrator program. There's evidence that show that if perpetrator programs exist outside the formal justice response, two things happen. Either it doesn't work or that the offender never completes it. And the reason for that is there's no accountability, there's no consequences, there's no deterrence. So if there's any perpetrator program, it has to come as part of a formal justice response system.
Thank you so much. And with that, I'll wrap the session. And I'd like to thank our panelists, Justice Mansour Ali Shah, Milana, Tavita, Genoveva Tisheva, Andy, and Emily Romerson. Thank you so much for your time. Thank you from calling in from all over the world. And we appreciate your insights and experience. Thank you so much.
Thank you very
Over
much.
to you.
Thank you.
That was an excellent session. So, we're really behind on time. We're behind about 30 minutes. So I think to compensate, it's a lot to compensate. So let's do 10-minute break before the next plenary session. And then I think for our longer breaks, or for Fiji-based participants, our dinner will just be shortened to 40 minutes. And then for virtual participants, it'll be like 40 minutes before we, get back on track for our last session, the breakout session. Okay, so 10 minutes, and we'll put the triangle on, that way and I'll also chase you down. So thanks to everyone for a really great conversation. Thanks.
Sim, hija, mamá, tarde. Huh? Yep, excellent. So welcome back, everyone. Thanks so much for coming back. It's really nice to stretch a bit and get some refreshments for our in-person. So I crunched some numbers and basically we're gonna have to shave off 30 minutes from our dinner break or our 1 hour break, unfortunately. And then we'll be back on track for the breakout sessions. So that's the interactive breakout session. So really appreciate it. So we'll kick off our plenary session 2. And this is where we discuss the good practices to increase confidence in the formal justice system. And I'm very pleased to introduce our moderator, the Honorable Dr. Robin Layton. She's just so dynamic and fantastic. So, she was a former Justice of the Supreme Court of Australia and is currently the adjunct professor at University of South Australia. And she's also one of our key experts for the our technical assistance. So I'll hand it off to Robin.
Thank you very much. And yes, welcome back. And I'm going to indicate that I'm going to be terrible on time. And by that, I mean the guillotine will come down. So first of all, thank you all for coming back, those of you that have come back and those of you that may be joining. As you know, this is on good practices in increasing confidence in the formal justice system. And we have 5 excellent panel contributors from a variety of backgrounds. We have 3 judges. We have an experienced senior legal advisor from the IDLO. And we also have our wonderful, I'm sorry, I'm just making sure I've got something in front of me that I have. Yes, our fabulous documentary maker and anthropologist, Miss Shah. So again, we have 8 minutes for each panelist. And at the 7-minute mark, a gong will sound. And that is going to be the beginning of the swan song at that point. So first of all, if I could go to the first of our panelists, and it's Justice Ananda Mohan Batari from Nepal. So as he is coming up, I'll introduce him. He is a justice in the Supreme Court. He's authored many books, and he's handed down many landmark decisions concerning the Constitution, human rights, gender justice, and criminal. And he is going to talk with us today about some of the innovations that have occurred in law and practice in Nepal. So the first question for you, Justice, is over recent years, Nepal has made many great strides with regard to the Constitution and other laws. Would you briefly give an overview of some of that and give some examples related to domestic violence, sexual harassment, and protection for women? If you could answer that question first. Thank you.
Thank you, Chair. Am I audible? Hello?
Yes, you are, and we can hear you.
Thank you. Thank you, Chair. Thank you, panelists. It's a great pleasure to be to participate in this symposia. And as to the question, in recent times, 3 of parallel developments have taken place in Nepal. The enactment of Constitution, the latest one. In fact, the journey started in 1990 when democracy was established in our country. The court was given the power of judicial review, and we started getting a very bold framework of right. The latest constitution is was promulgated by Constituent Assembly in 2015. But when we look at gender justice issues, we need to go back to start with 1990, when courts really began to look into international human rights law and taking inference from international human rights law, started issuing orders. For instance, in the first decade, courts recognized equal right to property of women, then non-discrimination in workplace, and marital rape was recognized as a crime. These developments were later taken into the Constitution itself. So the 2015 Constitution has a very bold framework of right so far as gender justice is concerned. Right of women against violence, right of women to equal property right, and family lineage, and so on and so forth. Right of the victim to information, participation in trial, compensation and rehabilitation. These were also recognized in the Constitution. Further, the Constitution also provided for inclusion, social security, mainstreaming of gender in the political process. These are considered as very good development in Nepal. So, and around that time, some acts were promulgated by Parliament. For instance, Domestic Violence Act is a pre-constitutional act enacted in 2009. Then after the promulgation of the Constitution, the second step was taken by the Supreme Court in revising our civil and criminal codes. Previously, we used to be governed by a very narrow framework of law. Now, this is a very comprehensive code that has a very strong bearing on gender justice, and also we also have a separate law on sentencing. So sentencing is not just finished on the same day as conviction is made. We conduct a separate hearing for on sentencing. These are the new developments. And then Victim Protection Act, that act was enacted in 2017. I refer to codes. These new codes, Criminal Code, Penal Code, Procedural Code, and the Sentencing Act. These were brought out in 2017. And then Children Act. This act was there even before the Constitution, but looking at the provision of the Constitution and development taking place in international human rights law, especially CRC, a new Children Act was enacted in 2017. And in the year 2017, we also brought out a new act on Safe Motherhood and Reproductive Health Right Act. And then there are two more acts which have a strong connection with gender justice: Witchcraft Accusation and Punishment Act, and Sexual Harassment Prevention Act. These are the new developments that have taken place in the last couple of years in Nepal. This is generally the legal framework that I wanted to bring to the August gathering. Thank you.
Thank you very much. Nepal has certainly taken a very comprehensive approach, and you're well ahead of many countries. So well done to Nepal for doing that. Could I now come to the second question, which is, could you also share how sexual offences, including rape, domestic violence and trafficking, are dealt with under your new codes, and how gender justice is achieved for women and girls in practice?
To this question, I would like to say that being a small country is an advantage. In an advantage in the sense that when you move things and develop consensus, it is not that difficult to bring out legislation or raise the issue in the court of law. Coming to how we have done on how we have been doing on gender justice, I will not limit myself to the gender-based violence. It has to be looked from a very broader perspective. For instance, equal right, guaranteeing equal property right to women. In a rural country, an agricultural country in like Nepal, where the most of the capital lies in the land, real estate. If you do not give equal share to this real estate and property, land property, then there will be asymmetrical relation always. So therefore, recognition of equal right to property was a landmark initiative of the Supreme Court. And in conjunction with that, the court also recognized right to tenancy, right to inheritance, equal right to inheritance, all these things. Another issue that came up to the Supreme Court was right to identity. Till a few years back, children could get citizenship in the name by producing document of their fathers. Mothers did not have a right to grant citizenship to children. Now the Supreme Court said, based on the provision of the Constitution, no, children can apply for citizenship based on the citizenship of their mother. So this right, this recognition really is the problem of children who were brought up by single mothers or whose family was disturbed, family relations were disturbed. Another is recognition of marital rape as a crime. This was the initiative taken by the Supreme Court. Later, it found a place in the Constitution, and now this is penalized by in the new code. So the punishment can go up to 5 years in marital rape. And then
could I just ask you to pause there for a moment, just bearing in mind time. I was going to be very fierce on this, so thank you for that. And if I could just move on to compensation, and in particular with regard to gender-based violence. Could you tell us something about how that is dealt with in the sentencing process in Nepal?
On this, I should say that now compensation is an overarching concept in the criminal justice. In every sort of crime, if there is a victim and the case is brought to the court, it's the duty of the judge to award compensation. And by compensation, also I also mean interim relief. Interim relief such as medical expenses or cost that has to be borne by victims during the trial. These are also covered by the Compensation Act. We have a separate Compensation Act based on the provision of the Constitution, and the code also comprises provision for compensation. So while conducting a sentencing hearing, the judge looks into the victim's perspective and awards compensation. And in the last 2 years, I have got the report that 30 million Nepali rupees has been paid to the victims to compensate them. So this has also taken a momentum in Nepal.
Well, thank you very much for that, Justice. And we have very much enjoyed your presence today. I understand you may have to leave before the end, but thank you so much for your contribution.
I should. I'll be here till 10:30 Nepal time. Thank you.
And if I could now move to our second panelist, who is the Honourable Judge Robin Tupman from New South Wales in Australia. And she has been a judge and still is a judge in the trial court in New South Wales in Australia. And she's particularly been involved in setting up a child sexual offence evidence pilot scheme. And she's going to be largely contributing to our session today about that. So Justice Tupman, if I could ask you, you've had a long interest in children's law and sexual assault. Could you share with us this important work that you've done with regard to the pilot scheme and explain a little of how it was set up and why?
Thank you. Thank you very much for inviting me to participate. I'm very pleased to do so. There were long criticisms leading up to 2015 in New South Wales, as there have been over many jurisdictions in the world, that the experience of children who claim to have been sexually abused was not producing the best evidence, and the court system was re-victimising and traumatising the children. This was something that was being done, followed up in the UK, and there was there were several task forces in New South Wales, and this particular one decided that they wanted to introduce a pilot evidence program so that all of the evidence of children, not just the evidence in chief, which is what we'd been doing for a while anyway, but all of the evidence of children would be pre-recorded, dealt with as quickly as possible after they were committed to trial for trial to our court, and then actually played as, I call it a product, but nonetheless played as the evidence of that witness at the subsequent trial, which could well be months down the track. The purpose of it was, of course, to try and reduce the trauma to children, and to try to have the best evidence available, because it was as quickly as possible after the charges had been laid, and we didn't then have the problems of which we are all aware of children, particularly young children, having memory issues after a considerable period of time. It could well be 18 months to 2 years or so before the trial got on, and then young children in particular would forget a lot of the surrounding detail. That was said to be inconsistencies, and it meant that you weren't getting the best evidence possible. We've long had in New South Wales, since the early beginning of the early 2000s, alternate means of children giving evidence. They don't have to give evidence in court. They don't have to confront the person who they're accusing. Most of the time they give their evidence from closed circuit television rooms. But this was a real innovation. It was twofold. First of all, giving all of the evidence all at once, pre-recorded, and hopefully never have to come back again. And in fact, there's a provision in the legislation that says children in those circumstances can only be recalled to give further evidence with the leave of the court, and a practice that leave should only be granted sparingly. And that's the way it's happened. And then the other arm of the program was to introduce the concept of intermediaries, which had long been, which had been in place in the UK and a couple of other parts of the world, but they're particularly people who were able to effectively translate children, not from one language to another, but to assist to ensure that children's evidence could be understood and that children could understand the evidence. Again, the whole point being reduce trauma and ensure that the best evidence available was in fact what was being given. It had a political imperative at the time. It was supported by the government, and it could only have happened if, I think, if there hadn't, it would not have happened unless the government of the day had been behind it, because in our system, it required that sort of impetus to get it up and running.
Thank you. And how effective has that been found to be? Has there been any evaluation of its effectiveness and whether it's fulfilling its purposes?
There has been. The last evaluation that I have seen was 2018, I think it was. No, yeah, 2019. 2019, and look, it seems to be effective. Of course, it really all depends on how you define effective. I know that some in the community might define that as being the number of convictions obtained. As a judge, working in a criminal justice common law system, it doesn't seem to me that that is the right way to define effectiveness, because it still has to be proof beyond reasonable doubt in a common law jurisdiction. What it has done, however, it has been found to work in terms of reducing the trauma to children. Their evidence is being given more quickly than it ever was, and there are very few occasions on which they're required or there's any application for them to come back. It's also had a culture change impact on the profession as well. As you can probably imagine, the defence bar was not particularly fond of this initially, because barristers seem to think that everybody has to be all in court at the same time, and it was all never going to work and it was going to be terribly complicated, some of which is true. But they've actually come round most of the time to seeing that it does work, and that people are not necessarily being convicted when it's not appropriate for them to be convicted. One of the things that seems to have happened, although it's apparently early days according to those who are evaluating it, is it has actually increased the pleas of guilty for these sorts of offences. And we had very few pleas of guilty for these sorts of offences because our penalties are quite high. So, you know, there's not a great deal of reason to plead guilty to these sorts of offences because of the penalties being so high. But there has been an increase, and that is said to probably be as a result of the improved quality of the evidence from the children. And that we've only got it in two places. It's a pilot. We have it in Sydney and in Newcastle, which is a city about 100 kilometres north of Sydney, a fairly big area. And it does seem to be working. The intermediaries in particular are being well regarded. But there's room for improvement. Some of the defence bar is still not 100% happy that everything is as fair as it should be, and I think that sometimes that's probably right, and we need to be very careful about that. But yes, it's been evaluated, and it's been continued now until the end of June this year. I'm not quite sure what will happen. But the other thing I should have said is that part of the program was to introduce 2 specialist child sexual assault judges. And they are largely the 2 people who do most of these pre-recordings now. And I no longer run the program. It's kind of evolved now, and it's being taken over by the more junior judges who've now become the specialist judges who are running it. That seems to be working well. It's quite resource intensive so far as the court is concerned, however, which is amongst the reasons I have no doubt that so far the pilot hasn't been extended beyond the 2 cities where it's running.
And when you talk about resourcing, what are the particular things that need resourcing with this system?
Well, the first of all is judges, because it really means that you have 2 judges who largely spend their time doing these pre-recordings. And it's not just the pre-recordings, but the whole of the system introduces a ground rules hearing, which involves the intermediaries, which happens as a first step, so that everybody is on the same page, defence, Crown, everybody, about what particular needs a particular child might have in terms of understanding questions, how to put questions, and all of those sorts of things. So that needs to be not adjudicated on, or at least presided over by a judge. And then the pre-recordings as well need to be presided over by a judge. So if you think about it, that means that there are 2 judges who can't do anything else, more or less. They do some trials, some of these trials, but they don't have to do the ultimate trial. So that's 2 judges and their court staff. There's a fair bit of technology involved that has to work well, and that's been one of the criticisms, that it hasn't universally worked well, that some of the quality of the recordings isn't good. And there was quite a few teething problems with the technology, which we largely overcame. Also, the intermediaries need to be high quality, and they're paid. They're obviously paid by the government. And so they're the sorts of resources. Yeah, that's what I'm talking about. Yeah.
Thank you. And my final quick question for you is there anything, a personal anecdote you'd like to share about your experience?
Well, sometimes you never quite know whether what you're doing is working or not, and how best you would assess that as a judge. I did one of the very first pre-recordings because I thought I'd better do it myself just to make sure if I knew how it was working. And we work very closely with the specialist police unit that deals with child sexual assault, the child sexual assault police unit. It's very important that everybody, all of the stakeholders in a system like this, all work together, and that nobody feels that they're left out. So I work quite closely with the police to ensure that they provided all of the evidence, that everybody had everything on the same page. They got back to me after the first one that I did, with some feedback. That evidence was given by the young girl. She was about 14, I think, something like that. She'd already had her evidence in chief pre-recorded, but she had all her cross-examination pre-recorded. It was all done in court. All of the objections were dealt with and taken, and the feedback to me from them was that the parents rang them and said, "We're so pleased that we agreed to do this. We're a little bit reticent to start with, but can I just say how great it is, because it's now done, it's over and done with, and she can forget about it now and move on with her life," which is, of course, one of the reasons why we did this. To be honest, I don't even know what happened to that trial. It was dealt with by somebody else, not by me. And probably, from what I know of the evidence, the person probably got convicted, but I don't really know. But it was nice to know that it had the desired impact for her, for the victim of or the complainant.
Well, thank you very much for. I'm sorry, Judge.
Can I just say that I think Nikita has a whole bunch of the legislation that
don't you worry about the questions. We'll do those at the end.
Okay, there's a lot of legislation. I gave them to her, and that can all be shared with people if they want to see what we did to put into legislative effect. Okay.
Sure. Thank you so much for that contribution, and I'm sure there'll be questions later. If I can now come to the third of our panelists, and it's the Honourable Judge Shahseeb Saeed from Pakistan, and he's occupied many positions in the jurisdictions of Punjab, and also he's worked in the Punjab Judicial Academy, and he's going to share with us today his experience with the before, during and after of the setting up of the first gender-based violence court in Lahore. So my first question, Judge, is you've been involved right from the start. What can you tell us about that?
Thank you, Robin. I'm grateful that you have provided me this opportunity to share my experience on this core issue. Yes, I have been involved right from the start for setting up the first pilot GBV in Lahore, following the combined initiative of the Honourable Justice Mansour Shah and the Adb. Gender bias is a phenomenon which is very prevalent in our societies, but in patriarchal culture, it is in augmented form. Let me say that gender bias discrimination in the criminal justice system makes substantial impediments, barriers to achieve access to justice for all. Let me show you a snap. Women faces significant barriers in achieving access to justice, whether they are victims, witnesses, alleged offenders, or prisoners. That snap says it all. Lack of conducive environment was the reason for low conviction rate. And victims were reluctant to appear in court for evidence, as observed by Justice Mansour Shah in the recent judgment in the Supreme Court that in rape case, it is the accused who is on trial, not the victim. Criminal justice system previously tend to focus on the needs of the predominantly male population of the offenders and prisoners. And Pakistan was no exception to that. But a sea of change was introduced in 2016. Prior to that, a special focus and attention given to the sensitive issue, and the situation was in shambles. The data collected and indicated that in Pakistan, only 2-3% of the rape offenders were convicted. In this backdrop, Justice Mansour Shah, Honourable Judge Supreme Court, the then Chief Justice of the Lahore High Court, invited the Asian Development Bank to provide technical assistance on judicial training, capacity building initiative, and to establish the first ever gender-based violence court in Asia. Let me show you the snap of the training modules designed by the Adb team. The extensive training on gender-sensitive issue was an eye-opener to identify and realize the issue faced by the woman, particularly victim day in and day out in the system of Pakistan. A program was conceived with the objective to provide a series of gender sensitivity and gender-based violence training that emphasize understanding gender stereotypes, bias, and gender-based violence. The general atmosphere of the course, example, the loud environment, the imposing counsel, and the close proximity, that was the most important feature of the victim survivor to the perpetrator, combined to intimidate and traumatize victim survivors. There was also need to understand and address gender bias in court. In this regard, training was imparted to judicial officers in the Punjab Civil Academy to sensitize them and realize the greater perception of the society of victim shaming. The most important feature of that program was that the practice notes were devised and guidelines were issued by the Honorable High Court for GBV courts for recording evidence of victim of GBV case, and the cases of rape trial, other GBV cases were put on fast track. The result of this effort was amazing, and it made high evidence. In less than a year, the conviction rate for rape cases tried in a specialized court rose from 0 to 16.5%. Yes, Robin.
And can you tell us, since that time, what have you been doing with regard to, for example, the training of judges yourself after that preliminary stage during the setting up of the gender-based violence court?
Yes, Robin, I have received training from Adb team on this issue, and I have also imparted training to almost all the judicial officers in the Punjab Academy. The key issue to me and major obstacle was to change the age-old medical mindset of the society in general and institution in particular. Considering the socio-economic situation in Pakistan, it is a foregone conclusion that it is a male-dominated society. And as you know, that de-learning is always a challenging and cumbersome process. As I just said, that the main complication in imparting training was to change the mindset and gender stereotyping. The concept of, you can say that victim shaming and considering that the victim has some nefarious design behind these acquisitions is deeply embedded in Pakistani culture. It is estimated that less than 10% of the female victim survivors globally seek assistance from this system. Thus, our main focus while training of this officer was on gender sensitization, gender laws and culture of Pakistan, relevance of international standards and gender sensitized judicial conduct and GBV against women. Yes, sir.
And you have organized training yourself, is that correct?
Yes. Yes.
What have you done there?
Yeah. When I was posted as a district judge in district in Dera Ghazi Khan, as a head of district judiciary, the foremost daunting task for me was to let the judicial officers identify the problem faced by the victim of GBV cases. Doing various meetings with my team, having special focus on GBV cases, awareness was created by learning the patriarchal mindset and shed the preconceived notions. As you can see in this map, that one day seminar was held, inviting all the stakeholders like judges, police, prosecutors, doctors, and training was imparted by the Adb team with the goal in mind to provide a conducive environment for the victim in GBV courts. And that proved great help. Previously, there was no mechanism for providing convenient posture to the victim in her pursuit for justice. As you can see, I'm sharing this map. It's a juvenile rape victim. She was hardly 8 to 9 years of age, and she was provided friendly atmosphere. It was easier for her to record evidence without being intimidated. The presence of accused was secured online. It was done with the consent of the parties, and so victim-friendly judicial system was created to control the variables which become impediment in the way of justice. As you can see, that I was more concerned about the safety and comfort of the victim. Otherwise, she would have been too frightened. When this was done, she spoke with clarity, and accused was convicted as per evidence on record. And after a gap, a conviction was passed in the case in Dera Radhika. Yes, Robin.
And finally, what do you think of the challenges now that lie ahead that can be improved in Lahore and Punjab?
At the cost of repetition, I have to emphasize that changing the mindset was the biggest challenge. Male humanistic societies deeply entrenched in macho culture are not ready to budge easily, let me say that. So to achieve this purpose, state actors, judicial system require more improving the ways of doing business, and technical and procedural hiccups lead to miscarriage of justice. Tedious process starting from registration of case, education is thorny road for victims. And there are some solutions and there are some suggestions. These are very exhaustive. But after establishing, let me say this with pride, that after establishing the first DBV court in Lahore, and after the amazing results given by that court, and now we have 36 DBV courts in all districts of Punjab, and almost 100 DBV courts in throughout Pakistan. Although the threshold is not big, but we have taken steps in the right direction. There are some legislation on anti-rape laws, and we in Pakistan are committed to guard and improve this journey. Yes, sir.
Well, thank you very much for that contribution, and thank you for the wonderful work that you're still continuing yourself, but also judges in Punjab. So thank you so much, Judge.
Thank you.
If I can now turn to our fourth panelist, and here we're going to hear from two people. They are between them going to contribute. The first is Ria Shongsong, who is the Senior Legal Advisor in the International Development Law Organization, the IDLO, and she leads the work on justice for women and spearheads the integration of gender in the Organization of Justice and the Rule of Law programs. And today she's going to share her presentation with another IDLO colleague, who's Jagalan, who's a Mongolian lawyer and with extensive experience again in gender and access to justice. So first of all, we're going to hear from Ria, who is going to talk about a research report that's coming up on access to justice for survivors of gender-based violence in complex contexts. Can you tell us, based on the IDLO's programming and research, what some of the promising practices are as a result of the research that has been done? Ria.
Thank you very much, Dr. Layton, and good morning to everyone. I'm talking from The Hague, so it's still very early morning. Yes, we are currently finalizing a research report, and this research really focuses on how do survivors of gender-based violence access justice when they are in complex situations. So this is a research that we've done with Global Women's Institute at George Washington University. It's an original research looking at 6 countries, Afghanistan, Honduras, Papua New Guinea, Philippines, South Sudan, and Tunisia, with an asterisk on Afghanistan, as the research was actually conducted prior to August 2021. And it looks at overlapping challenges of a health pandemic, natural disasters, conflict, fragility, legal pluralism, organized crime, among others. Like within this context, which we all know is a very difficult scenarios, how do survivors access justice, and what are some of the best practices, or at least promising approaches? So the paper is of significant length, so I'll just highlight some of the snapshots from the paper. One of the first things that came out there is that specialized mechanisms or units, specialized police, prosecution, or courts actually can help gender-based GBV survivors, but only if they're adequately resourced, closely monitored, and are meaningfully embedded in the justice system. So there has been several studies around specialized systems and evaluations that mention they don't work. But this is primarily because they are not adequately researched, they are marginalized within the system, and often not monitored as well. The second point I wanted to make is the primacy of protection orders that really came out a lot in the research. And here, protection orders, as we know, are very critical in building confidence in the justice system for GBV cases, especially when they're accessible, they're issued promptly, they're being monitored, and survivors are also offered support during the process. So,
could I just stop you there? I have a message that if you could please speak louder into the microphone, that would help. Sorry to have interrupted you, so that we can better hear you. Thank you.
I hope this is better. I'll try not to move. So protection orders are very important as long as they are accessible, issued promptly, monitored, and the survivors are actually supported through the process. So often there is a high rate of attrition between an interim protection order and a more temporary or permanent protection order. And there are many reasons for that, but one of the things that we've heard is primarily because of delay, lack of support, and even the use of mediation and informal or customary justice systems in between. The third point I wanted to make is around women justice professionals in the justice system are critical to increase confidence in the justice system itself. So not only are they important because it is a woman's right to participate in governance, including justice governance, but it also increases the representation of the justice system and supports broader access to justice. The last point I wanted to make is specialized mechanisms for data collection and review. And here we know that a key aspect of ensuring that justice meets internationally accepted standards is to regularly monitor justice systems, including the justice personnel. So monitoring and evaluation can address evidence gaps, identify best practices, inform law, policy, and practice. And this research that we've done is to contribute to that. But my colleague Jargalan will also talk about research that's carried out in Mongolia on trial monitoring and on justice chain on GBV. And I hope it would also provide more information around this types of work. So I'll stop there, and I'm sure I'm missing 5 other points on capacity building, legal aid, and a couple of items, but I'm happy to discuss it in the questions.
Thank you very much, Ria. And can you give us any indication when this report might be published?
I believe we are looking at the executive summary being published by July, and hopefully before the end of the year, the full report will be published, hopefully.
Thank you very much. Now, if I could turn to your colleague Jagalan, and if you could make your presentation.
Thank you, Dr. Robin Layton. I'd like to also express my gratitude to the conference organizers for the opportunity to share what we are doing in Mongolia in response in terms of response to gender-based violence and promoting victim-centered approach. So I would like to share with you my presentation. So IDELO began its operations in Mongolia since 2012, and since that time it is successfully implementing a number of projects and programs in Mongolia. So currently, IDELO Mongolia is implementing strengthening the response to gender-based violence in Mongolia project with the support from Government of Canada that aims to increase access to justice for victims of domestic violence that incorporates a victim-centered approach. So the key stakeholders of the projects include the Ministry of Justice and Home Affairs, Judicial General Council, National Police Agency, Prosecutors General Office, Mongolian Bar Association, and civil society organizations operating in the field to combat gender-based violence. within the framework of the project component to improve the response of justice sector to domestic violence, IDELA has conducted recently 2 studies that monitored and assessed application of a victim-centered approach in DV trials and DV cases along the justice chain. The objective of the studies were to conduct trial monitoring, analyze GBV regulatory and legal framework, and assess their level of implementation, and identify gaps and challenges, and to produce evidence-based report with recommendations on protecting the right of victims and improving supporting services for victims, and present the report to government agencies and stakeholders for further follow-up actions. So following the report of the study and stakeholders roundtable with government and civil society actors, and also including the representatives of the Human Rights Commission, the recommendations were distributed to all the justice sectors, key stakeholders, and to working group that was established under the Ministry of Justice and Home Affairs, which are now working at the moment on revising and making amendments to the laws on infringement and civil code. So the main findings and the recommendations came out from these 2 studies were related to the challenges in the legal framework, improving legal implementation, response of the justice sector and other organizations to combat domestic violence, and improving legislative framework. So in terms of concrete recommendations, for instance, came out from the trial monitoring. They were related to victim safety, victims' rights to access to information, and victims' rights to compensation. So in line with these recommendations, the Judicial General Council is revising the regulations on ensuring safety of trial participants, judges, courts, and court proceedings, and improving standards for informing complainants about the court schedules. And also the regulations indicate there's separate different entrances and exits at the court buildings. With regard to the right to compensation, so though the law on the law on combating domestic violence indicates 4 types of violence, the criminal code has a provision about just physical and sexual violences. And the other 2 types of violences, like economic and psychological violences, were left out of attention and were not legalized. So the Ministry of Justice recently revised the law on forensics, which creates the legislative environment for calculating, to include the psychological damages into the law, legalization of it, and for calculating psychological damages and providing compensation for DV victims. The recommendations came out from the Justice Chain research related to indigent victims, to providing legal assistance to indigent victims, and also use of victim-centered approach mechanisms by all justice sector actors, and also capacity building, training on the specific needs and vulnerabilities of DV voices and others. So in line with these recommendations, so the working group, which also is working under the Ministry of Justice, revised the law on legal aid in line and included these recommendations, and that include victims of domestic violence as beneficiaries. So the amended law expanded scope to include provision of legal aid to indigent victims of DV and child crime and child abuse crimes. In terms of capacity building, IDELA has incorporated a victim-centered approach in all practicing training to service providers, including police, lawyers, public defenders, and court administrative staff. and will provide also, in addition, we will conduct series of trainings for judges, police officers, and prosecutors in the fall of 2022. So this is the brief introduction of my presentation, and thank you for all your kind attention.
Well, thank you very much for that, Jaglan. It's very encouraging to see that such good research is done, but not only that there is good research done with good recommendations, but the recommendations are actually being acted upon. And that's a great credit. So well done for your organization, and well done for Mongolia for being so responsive. So thank you very much for your presentation, both of you. Thank you. And if I could move now to our final panelist, Sama Minelahan. I couldn't even get her name out last time, and I've worked with her over the last 4 years. What a tragedy that is. So Sama is going to talk to us today about how she uses her degree in anthropology together with her filmmaking experiences to actually challenge various forms of culturally sanctioned forms of violence. How she does that, how she uses the media, and then how she can use that with regard to training for judges and prosecutors. So Sama, if I could first of all ask you a question about your overall approach to addressing gender-based violence against women and girls through strategies aimed at prevention of violence.
Thank you, Robin. Thank you so much. As an anthropologist and a documentary filmmaker, I think in the area of advocacy, my background in anthropology has really helped me, because when it comes to addressing issues related to violence against women, I've tried my best to focus on culturally sanctioned forms of violence against women. And that's where my background in anthropology really helps a lot. So we still come across mindsets where if a woman has been raped, we don't focus on the fact that her self-worth, her dignity has been compromised. But in most of the societies, we hear that the family's honor has been compromised. So it is this particular mindset that I feel needs to be challenged through a culturally sensitive approach to advocacy and communications. Hence, what I focus on is working with local communities. When it comes to developing a particular strategy, it's actually the local partners who help us in designing that particular campaign. The short film that you saw in the beginning was actually made, the entire story, everything was developed with the help of our local partners in Timor-Leste. So that's what makes a particular tool more effective, when the local partners start to own that issue and are interested in using it as a tool for advocacy. So that's what I strongly focus on. And as you just mentioned, I focus on prevention, because I think that is the area that really needs a lot of focus when it comes to violence against women.
Thank you. And how do you know whether what you are developing as a result of the approach that you take is actually working? How do you self-monitor, as it were, the work that you're actually developing?
So, Robin, there are many ways of monitoring the impact of a particular campaign. But for me, as an anthropologist, the fact that the local communities or the civil society organizations are reaching out to us to use those tools for advocacy, that in itself I see as one of the indicators of success. Again, this film, I was pleasantly surprised where the main protagonist, Mana Maria, she said that I would like to use this film for advocacy in Timor-Leste and reach out to different local NGOs and organizations. And there were many challenges when we were working with Mana Maria, but in that process, her husband, her current husband, he has shown his support because of the way we were addressing this entire filmmaking approach. So I think when men come on board to address such issues, that I think really amplifies the message that we are trying to give out to people.
Thank you so much. And then maybe you can explain how you use some of that work with regard to the training of judges and prosecutors, because we have done work together,
yes,
along with Zari in Pakistan and also Afghanistan.
Yeah.
So can you tell us how you use your work in that?
Yes, so I've been lucky to have Sari and Robin on board, you know, when it comes to developing modules. We have worked together in Afghanistan, in Pakistan, but now what we are trying like a different approach, given the scenario of COVID, we think that technology has the answer. And unless we combine technology and training when it comes to reaching out to justice sector actors, we won't be able to bring about a lasting change. So that's what we are focusing on right now. We are developing e-modules. And I think, again, for that, we have experts like Zari and Robin. But again, we are developing these e-modules in a very customized manner. For example, the one that we are going to use in Timor-Leste, you'll see that it has that cultural sensitivities, nuances that would apply very effectively in that particular geographical background. I'll just give you a short example of how we are designing this e-module. It's a very short, a few seconds clip. Cecile, can we show the first clip, please? Yeah. So the aim of these modules, and we have quite a few different topics that we'll be addressing through the modules, but the aim is to have interactive, very interesting modules that have podcasts, that have explainer videos, that have different tools that can also be used separately for advocacy by different organizations addressing the issue of violence against women. Now, another example I'll show and share with you. Again, we've been working with the local partners in Timor-Leste. And when it comes to addressing different social and cultural backgrounds, here you will see a glimpse of what we are trying to share with our audiences. Again, we came across these different scenarios. There is a saying where, as in many other communities, that when it comes to cases of domestic violence, that is seen as a private matter, although the law says something else. So there's one scenario that focuses on this particular issue. Then there's another scenario focusing on victim blaming. So you'll just get a glimpse of these two issues, but then the kind of questions that have been designed, like MCQs and everything, those then focus on issues like these that we have pointed out in the modules. The next clip, please. Yeah.
Pikang kanuru baku malu. Mai ve feto mak provoca mane atau halu violência, né?
It is absolutely essential to have a good understanding of the legislation within a total cultural and social context. Every country is different. Every level of development of law is different. And all of those things need to be taken into account.
So this was just a brief glimpse of what we are working on right now, and we are hoping to then replicate it in other countries as well. So yes, that's about it. And thank you so much, Robin. Did I cover? Yeah.
I'll talk to you later. Thank you very much for giving that glimpse, because this is still a work in progress for us. And we're going to work around hypotheticals and do all sorts, because we do understand that judges have often been trained sometimes to death, so to speak.
I know.
And they want a different approach.
Yes.
And this is why we're trying to make it engaging, to try and still be able to get across some serious messages, some serious information, but they can do it in their own time, in their own way, but still be interactive.
Absolutely.
So that has completed the panelists, but we still have some good time to enable us to deal with some of the chats and some of the questions. So here I'm going to go over to our facilitator. Nikita, can you tell me whether there's any chats, because I can't see them on my screen. Our screens went a bit unusual.
No problem. Just to let you know as well, Justice Batari has had to leave for his other engagement, but has been answering questions in the chat that were addressed to him. So we've got some questions being answered, but there are a few that we can ask the panelists now. So I'll start with one for Jagarland, actually. There's a question about a remark she made in the presentation on the role of mediation in customary justice system. This is from Arundhati, who's asking, may I please ask if the research that IDLO have undertaken find any evidence of victims of gender-based violence in certain contexts like rural areas seeking reparational justice through the customary laws or justice route more, and how prevalent is this?
Nikita, I think that question was for me, so I'm happy to answer it. Yes, and of course, Jargalad, you can also answer it from Mongolia's side. But in the research that was done, yes, we did find that women seek justice through customary justice systems or through mediation as well. It was quite prevalent. Also depending on...
I'm sorry, you'll need to speak up, Ria. We can't hear you. Can you really talk loudly? Thank you.
I hope this is better.
Better.
Yes, we did find a lot of women actually use customary justice systems, depending, of course, on mostly location, cost, different identities of women. In many of the countries that were in the research, of course, we had Afghanistan, Papua New Guinea, South Sudan, etc. So it was quite prevalent. IDLO also has a separate research around women and customary justice systems. And in there, we do have, there's a lot of research that shows around 80 to 85% of women in many of the developing countries do use customary justice systems for many many concerns, including gender-based violence. So, and another research on Somalia, which we supported the Ministry of Justice put together protocols for their alternative dispute resolution systems. And of course, in addition to land cases, women often bring gender-based violence cases before these ADR centers. So there was a need to develop protocols around how to handle these cases, including referral systems.
Thank you. Before I take another of the chats, I might see if there's one from the floor here before I go through what other chat questions there may be. Anyone want to ask a question from the floor here of any of the panelists? Otherwise, I'll see what's in the chat. Okay, I'll go back to the chat. Are there any others, Nikita?
Yes, there are. So we've got a question for Judge Saeed. And this question's just about the training that's being conducted for judges and for prosecutors and lawyers, whether such similar training being expanded to, say, police, journalists, NGOs, civil societies, whether that's something that that sensitization training is needed in order to raise the quality of justice in cases of violence against women and children.
Thank you. Yes, when we talk about the changing of mindset, it is meant to change the mindset not only for judges but also for all the stakeholders, that like police, prosecutors, doctors, scholars, and social NGOs, etc. Because changing the mindset of only judges is not sufficient. We have to change the mindset of other stakeholders. As I said that while answering the question, that I conducted a seminar in Dehradun, and I invited all the stakeholders. We should also conduct these seminars in district level, and we should invite the elders of the society in that seminar so that they can disseminate the information gathered in the seminar. That is very important. I also invite the doctors so that they can have the knowledge of the understanding of the latest law. For example, doping test that was held unconstitutional, but not only by the High Court but also by the Supreme Court. Yes, I agree with the question that the other stakeholders, other state actors should also be invited, and their should also be their efforts should be done to change the mindset. Yes, that's enough.
Do you want to add to that at all? Just
The
about
mindset
your advocacy.
Yes.
This is something that Sama may also contribute to, because she's been involved in some of the advocacy, which very much involves the civil society.
Yeah.
Sama.
So I completely agree with Shahzaib Saab. Actually, this came about with our discussions at the Judicial Academy in Pakistan. And one of the issues that the judges that we were going to train, they pointed out that it is the mindset that needs to be addressed. So whatever you are developing or designing, kindly focus on these areas, especially honor-related crimes, where honor is linked to a woman or a girl's body. So these were the kind of points that really helped us in developing an advocacy campaign. So yes, absolutely, changing mindset at different level is very, very important when it comes to violence against women.
And thank you. I think we have time for another chat question. Nikita?
Brilliant. This question is out to all the panelists. It's from Tavita asking, when dealing with domestic violence cases and when the court is making referrals to counselling services and mediation, are there any criteria about these services? The question comes because sometimes the people and organisations doing this reinforce stereotypes and expectations that promote gender inequality or justify domestic violence. And specifically, they're looking for examples from jurisdictions outside of the Pacific.
I wonder if I can turn to somebody from the IDLO. Ria, would you be able to contribute to that? And if you could speak right up to the microphone.
I'll give it a try. For example, CEDAW general recommendation actually has guidance. The latest one on gender-based violence, CEDAW general recommendation number 35, actually has guidance around the use of mediation. Also, the Council of Europe's Istanbul Convention also has guidance around that. We're pretty much, the shift has moved from no mediation, and I think this is listening to a lot of the voices of women survivors, to no forced mediations. And then the other guidance around that was that the series of caveats that are attached to any mediation or alternative dispute resolution that happens in cases of gender-based violence. So primarily, of course, support services has to be there, the referral system, sufficiently trained staff, etc. So without those in place, then mediation cannot happen. So I shared our work in Somalia, and actually that was one of the challenge where pretty much we were requested guidance on how to proceed on a protocol with ADR systems that are pretty much, a lot of cases on GBV are referred to it. And what do they need to do? Do they just say, we can't deal with it, go look for another, institution? Or should we ensure that they ensure the safety of the women, ensure referral systems, etc., and they're properly trained to handle these cases? So I would suggest GR 35 is probably a good guidance for this.
Thank you very much, Ria. I think we'll wind it up now. So in winding up, I just want to thank the panelists so much for the contributions they've made. You've done a wonderful job. And I just look forward at some point to finding out some of the further progress that's going to happen in the cases that you have all referred to. So thank you very much. And also thanks to all of the people that have been participating generally in this. And I will say the session is over and hand back to Christina.
Thank you. Yes, this concludes our plenary sessions, and really appreciate all your, commitment. So I just want to give some directions. So we're going to have a 30-minute break. So for Fijian participants, there's some food and you can walk around, and for virtual participants, you could take a break. So, just when you come back though, so you're going to be in your different sessions, right? So for this plenary session, you can keep the same link. So that's session 3C for CSOs and survivor victim advocates. But if you're, in the judicial session 3A, there's a separate room and a separate Zoom link that you have to log into. Same with the prosecutor session, which is 3B. So if you're in person, it's there's a separate room, and then there's a separate Zoom link for prosecutors. Otherwise, everyone just comes back to the same Zoom link and this main room if you're in session 3C. Okay, so have a great break. So 30 minutes. Thank you.
Thank you. Thank you.
So we can shut our computers.
Yes.
Okay, everyone needs to stretch. That went well.
Yes.
Except for people we couldn't hear. I couldn't hear Shazib. I couldn't really understand him.
Yeah,
I mean, I knew his story.
switch on. hello. To our justices who are currently on session 3C, please, I have messaged you through the chat your individual login links for session 3A. Please log off this session so you can join session 3A. And please use the links that I have typed up in the chat. To our justices who are currently in this current session, session 3A is now open for joining. Please log off this call so that you can, and then use the links that I have typed up in the chat for you, so that you may be so that you'd be able to join session 3A. Thank you.
Can't see the links.
For our judges who are currently on session 3C, session 3A is a closed session for judges.
And the other link to the other session?
Yes, for the other session. Hold on, please. Yes. For those who are currently in this session and you are part of an NGO or a CSO, please remain in this session.
The saved program that you've had on YouTube, is that being saved to YouTube so we can re-watch it?
Yes, we have the links on live stream on YouTube. We will distribute the link later.
Fantastic. Thank you.
Been committed to human rights and equality with particular focus on the rights of women. In 2019, she was awarded the Australian Human Rights Commission Human Rights Award, Law Award. And in 2021, she was appointed as a member of the Order of Australia for significant service to the law, human rights, and to the professional organization. And in 2022, she was awarded Lifetime Achievement Award by Women Lawyers Association. And I believe just this morning, she received another award. And we are just grateful that she's made time to join us and moderate this session. So Kate, welcome. And I will hand over the floor to you as the moderator. Thanks.
Well, thank you, Christina, and good morning or good afternoon to everybody joining us. I so wish I was with you in Fiji, but as you can see, I'm here in my office in Sydney, joining remotely. It's a great pleasure and honour to be moderating this session. We're going to look at victim survivor advocates and civil society organisations. We have an excellent panel today. You have their biographies in the conference pack, but I just thought I might briefly introduce everyone. I can see, Christina, with you in Fiji, I hope, is Nalini Singh, the Executive Director, Fiji Women's Rights Movement. Nalini is a feminist and a social development specialist. I also hope with you in Fiji is Lily Mewanu Viayasu. She's a lawyer, activist, and advocate for human rights, and she recently joined the International Finance Corporation World Bank Group as a gender and childcare consultant. Now, virtually joining us, I can see Barbara de Oliveira, who's just given us a wave, who's joining us from Timor-Leste. She's a human rights lawyer, but she's also founded JUS, Juridico Social Consultoria. I probably didn't pronounce that with the right accent, Barbara, but welcome. I can also see on the screen Henry Cornwall, who is one of the counsel at the bank, and he's implementing projects to strengthen community policing legal systems to protect and uplift survivors of gender-based violence in Nepal and Fiji. Welcome, Henry. Now, I hope also, and I can't see you, Asmita, on the screen, but Asmita Basu, a law, gender and human rights specialist with 20 years experience in project management. Oh, there she is. Welcome. Research, advocacy in gender and human rights. Now, very sadly, a final member of our panel, Kate Martin, who's the Pro Bono Director, Asia Pacific at DLA Piper, sadly told us that she's unwell and she's lost her voice. So she's not able to join us today, but she's raised with me a few points and I'll try to incorporate them in the conversation we have this afternoon. So warm welcome to all members of the panel. In terms of how we use the precious time that we have today, I thought we might divide the panel discussion into three parts. To start by asking each of our panelists to talk to us about their particular experiences and matters of concern to them. And I've sort of said to them 5 to 8 minutes, we'll see how we go. Then part two, and this is where I'll bring Henry in, is I want to talk about particular issues and to open up a discussion to draw on the expertise of all members of the panel to really look at the role of victim survivor advocates in the judicial system how we build capacity for advocates, including human rights approaches, and we can talk about trauma-informed approaches. And then part 3, based on the panel's expertise, looking forward. So what needs to happen to achieve integrated support services to support victim survivors in the judicial system? And again, I hope that we can have a discussion, and the team are going to assist me if questions come in, and if it's appropriate, I'll incorporate those questions into the panel discussion. So against that background, can I turn to our colleagues who are there in person? And Nalini, would you like to start? I wonder if you could share your experiences and work on law reform in Fiji and some of your experiences as a victim survivor advocate. Thank you.
Good Abinaka, everyone. I hope you can hear me. Thank you so much, Christina and the ADB team for this invitation. I think it's great to be in a room full of colleagues who are on the same field. I think we'll be speaking, very similar stories and hopefully recommendations in the end. But I just wanted to say that for Fiji Women's Rights Movement, being, as Kate's mentioned, an organization that has evidence-based advocacy for legislative, policy, and institutional reform. One of the areas that we really focused on is access to justice. We've been at the cornerstone of reviewing and ensuring that we have legislation that works for women, and a few that were named earlier by Millie from the Crisis Center. That's the Fiji family law, the domestic violence laws, moving into even the employment laws where we are, tackling sexual harassment, faced by majority women in the workplace. So a few years ago, in fact, in 2017, we released a fairly, I think, profound research findings for a research called Balancing the Scales, where we looked at data and evidence from, all the formal justice sector institutions, and, actually looked at whether, the purpose for the advocacy effort we had put in, for the last 3 decades, the women's movement in its entirety had gone through a lot of struggles to ensure that the laws, at least on a substantive size, were, looking after women's needs. And Balancing the Scales, which is what the research is called, had many, we used 8 different methodologies to come up with analysis from, looking at the police statistics, the DPP's statistics, the court analysis, data from both the family courts, and as well as looking at the statistics around rape and sexual assault. And we also went and visited every court setting in Fiji where we knew the family matters were being taken through, as well as we spoke to as many women as we could to see, whether the triangulation of our findings were coming through. So the, findings are profound, and many recommendations, many have been taken up by the formal justice sector agencies. And, a lot had to do with the data, because we need to have disaggregated data along at least 6 to make sure that we get to looking at, what does that say for us? But when we spoke to the women who had stepped into the formal justice sector arena to seek justice for what kinds of violence they were suffering from, we found that for Fijian women, it was taking 868 days on an average for women to, reach out and seek help from the formal justice sector. And the list of barriers, and I think this has been talked about since the opening plenary, both Morrison and Adb talked about it, the first being that it's so complex, the court processes. The women don't know how to reach that. Women don't even know how to reach to the counselors, the services that have been provided so that they can, step into the processes. The cost of, transport, because it's not just one trip and everything gets done, it's multiple. Then who looks after the family, when she is away? And then, of course, we have the whole host of other things that Millie talked about around attitude from police officers, court clerks in the registries, etc., which is really not conducive to women. So then if we're talking about what have we done since then, we have now an ongoing strategy which tries to address this particular issue of at least the justice pathways. We are now working with a number of local community-based organizations who are, informed of the various pathways, and then they incorporate it into the work that they're doing with communities, so that at least the information around, what phone number to use, which office to go to, where is the crisis center, where is the MSP, where's Empower, what kind of help is being provided, the nearest police station, who should you approach, that all that kind of information is being passed through. So it's painstaking work because this requires a lot of resources. It requires the ability, to spread the information without being, labeled as troublemakers. So, this information is incorporated into existing work that the local partners do across the different countries, different areas of the country, and at least the information is going out there. What we see, I think, in comparison to what we saw earlier on, to say, for example, in Vanuatu, where there's about 98% of the cases, not reported, at least here in Fiji, we can see and triangulate that with at least the number of phone calls, that goes to the national helpline. We can see that, at least women and even men who are much more aware about, those numbers being used, and they know where to get services from. But, it's not done yet. This work has to continue for, a very long time, in my opinion. If you're looking at the formal justice sector, well, few improvements have happened. One around, we have in the Pacific, with the University of South Pacific, a very good online repository of where all the case sentences judgments are deposited. But we had this issue around the family law judgments. We couldn't analyze that because they were not anonymized, not redacted. So that was one of our key recommendations, to ensure that that is done, and it's being done now. So, any ongoing work to see, well, how long does it take, women? Because once they get into the justice sector pathways, it's not always very smooth or fast processes. I mean, they're in it, and they could be in it if it is around family matters for a long while, because there's individual processes that happen, one at a time. So we were also looking at, well, how to avoid that, how do we get that fast-tracked if it can be? So now that we have the cases redacted and online, that could be another area of research that we could be doing, to look at, well, how long does it take? And, when we visited all the court settings, we find that, the maritime areas, the island court settings, these are, where the entire judicial system, the formal justice sector, travels into the maritime areas. And, these are the underserved areas. 3-4 times the court sits, because they're traveling on boats, and but that doesn't mean that crime and violence doesn't happen only when, you know, when the courts are traveling. What that leads to is that, you know, the perpetrator and the victim survivors are together in the community. You know, and the attitudes, the community level is, of course, as we know, very patriarchal. There's a lot of victim blaming, and, you know, there's a lot of what we saw was men interacting with the court officials that are going, and usually it is all male officials that are going on these trips. So the recommendations around that, well, we have yet to see what has happened. We see improvements in family court when it comes to children, where there are, in some instances, services provided, especially to cater for children, when the cases are ongoing. There are some improvements when it is involving children as victims of sexual assault. You know, in terms of when we say not putting the victim survivor in front of the perpetrator, etc. You know, there are other means being used. So there's a whole host of some very, I would say, good things that we've heard from the other countries being implemented in Fiji, but you know, we saw all the gaps and the holes appear during the COVID period. When we look at the statistics around the number of calls the crisis center got on the helplines and their phones, and other service providers saying, oh yes, number of women, men and children approaching for services has increased in, astronomically. But at the same time, when we then look at, well, what has happened in the processing end, how many cases did go through court, then it is just a small fraction. So this leaves us to wonder what is happening to all those other victim survivors who in one way or the other, you know, have not reached the formal justice sector or are in process. Who is looking after them? You know, where's the counseling support? Are they still in contact with the perpetrator? What is happening? So that has happened, and we are wondering what will the responses be from the judiciary side. I think the second thing here that we see is, you know, the trauma that happens with prolonged cases. And yeah, what kind of services are there? You know, are they compensated for that or not? There are, you know, regulations around it, but it's never been enforced. So that's a conversation that Lily and I were having on the table. I think the third thing would be that, you know, we know through our ongoing analysis. So we've taken on, the Fiji Women's Rights Movement has taken upon itself with no funding to keep the analysis going on for rape cases that we get to see every year. And we see that, you know, the average sentences that the accused, you know, that his sentence gets around 12 years, fairly long sentence from, you know, our, you know, say a few decades ago. But we see that, you know, when we look at the type of crime that is committed against, you know, women or, you know, those that are victim survivors, then we see that it is rather inadequate in that way. So, and we see in the cases of perhaps say first-time offenders, that, you know, treating convicted persons as having previously good character and having that mitigate sentences, you know, we don't see the point of that. You know, for classic cases is the few cases we've seen on with the rugby players, you know, famous people, and that happens. And I think the last point I'm making here is that, you know, with the women's movement, the feminist movement, we are very clear that, you know, such crimes, you know, manifest in patriarchy, you know, that, you know, violence is all about power over the other. And so, you know, it's manifested in patriarchy. We've talked about the initiative and the whole government and the country, you know, we've said that, you know, it is all about that kind of gender inequality. But then when women step into, have the enormous courage and support and step into the formal justice sector pathways, And we find that that too is patriarchal. You know, that too is patriarchal in terms of attitudes and behavior that they witness. So, you know, so it was very interesting, and we were all murmuring on our side when we heard the learned judge from Pakistan talk about his courts being not considering gender. And I have a particular take on that one as well, to say that, and we say it for almost all the other areas of work, is that being, you know, gender neutrality does not result in gender responsive outcomes, you know, in any sector of work, and including the courts, because what we are dealing with is, you know, all pervasive, centuries deep, you know, patriarchal attitudes. So we do have to be gender responsive. I know that the law stands to be neutral, but when it comes to certain crimes that are perpetuated against women and girls, I think the courts too need to be gender responsive. Kate?
Thank you very much. That's a wide range of issues, I think, for us to discuss as we continue with the panel today. Lily, can I turn to you? You've had experience practicing as a lawyer. We're still getting, Angela, a little bit of feedback. So Lily, I don't know if you can hear me over the top of the other voice, but can you talk about some of those experiences that you have as an advocate working in the area of family and criminal law? Thank you.
As the stakeholders,
Lily, I think you have probably have to compete with the other voice. I'm sorry about that.
Lizario, sorry, can you, you're not in the correct language channel. Can you please, thank you.
Thanks, Kate. So I have several different hats on at the moment, not just as a survivor advocate, but also as a lawyer practicing in the area of family law. So we've been here half a day, and we've heard from several different agencies, legal practitioners within this space. And so I don't want to repeat some of the points that have already been raised, but just adding to what's already been said. Firstly, in terms of my experience in the family law space, I've just, I found that there's been a lot of progress made, particularly since the advent of the Fiji Family Law Act in 2003. And I've seen how it has assisted women, in particular, access the justice system. However, what I've come to observe over the years, having practiced in the family law courts, particularly here in Suva, is that there's almost like a manipulation of legal proceedings by perpetrators, and particularly applicants who are spouses, husbands, particularly male partners. And if you take into consideration the context around how women find it very difficult to access legal systems and legal services, how they're, they find it difficult to find particularly good representation, legal representation. It kind of gives you an idea of just the struggles that they face when they're in the court system. And I've seen, cases where particularly, spouses have lapped on different applications after application, whether it be a modification to a contact or access order, or a modification to maintenance orders for financial support. And just seeing how, these women in particular give up, right? Because the matter's either taken too long, or they've just, thrown in the towel because they can't afford to continue to come to court. And so, I've
in my experience, particularly not just with working for a leading women's rights organization in the past, but also in the private sector, having practiced privately, trying to get private lawyers, legal representation to provide pro bono assistance has been quite difficult. So that's one concern that I have noticed. The other is, just the duration by which a court case, whether it be custody or child maintenance or even a child recovery case, takes within the legal system. And I think, Nalini had alluded to this earlier. The fact that it takes so long is in and of itself, justice delayed is justice denied, right? And I've seen how sometimes judicial officials can be so blind to the issues that are there before them. We heard from our learned judge earlier from Pakistan. And the fact that, gender, notions around gender are not taken into account. It's left at the door. That can be very difficult, particularly when you're looking at statistics that show a vast majority of women are victims of domestic violence, domestic and sexual violence, and the vast majority of perpetrators are men. And so when you're looking at the gendered nature of these offenses, it can be very difficult, particularly if you're a person who has grown up in this society that has accepted, that this is the way women are treated as second-class citizens. How can we be sure that it won't filter in or trickle into how you make decisions in the court, right? So it's really important that for us as representatives of the bar, but also civil society organizations and other actors in the room who provide assistance to survivors and victims of violence, that we are partnering together to ensure a more gender responsive judicial system. Aside from that, I've not seen, and over the years, I've seen only recently, the parallel application of the Domestic Violence Act and the the Crimes Act of Fiji. I recall a couple of years ago, Madam Nazat Shamim saying, that there hasn't been a parallel application of these two legislations, right? Because when we look at the Domestic Violence Act, the Domestic Violence Act gives rise to the DVRO, which is the Domestic Violence Restraining Order. But that only protects the victim or the survivor, right? It does not necessarily criminalize the act of the perpetrator. It is important, and for example, if it was a stranger violence, right? Someone came and, assaulted you, you would be facing the criminal courts. But in this situation, you have intimate partner violence being committed here, which also is a criminal offense, but they escape the criminal justice system. So there's that aspect. Another aspect that I've also noticed, particularly within the criminal courts, is this issue of grooming, which is an issue that my colleague here, Nalini, and I were talking about. And that's evident in a lot of sexual violence cases involving children, right, minors. This is an issue that there's been a lot of jurisprudence being developed all across the world, particularly in South Africa, the US, in Australia as well. Not so much here in Fiji, but there are subtleties within the criminal proceedings, particularly where sexual violence is involved, where grooming is an aspect that is not taken into consideration. And grooming, for those of us who might not know, is perpetrators making that emotional connection with a child, preparing them basically for sexual abuse, right, or sexual activity. And so this is an issue that could be taken into account, particularly when you're looking at sentencing of sex offenders, right? One aggravating factor might be age, right? The age of the complainant or the victim survivor. But then, you know, if you look at the aspect of grooming and how over time they've actually prepared the victim or survivor to perform sexual acts, these are issues that not necessarily are being taken into account. So that's another aspect that I also wanted to share, including just, you know, we have some fantastic laws, I have to say that, in terms of, you know, ensuring that gender equality, gender-based violence are addressed within the courts. But again, it goes back to law enforcement and also the just the way in which the laws are applied. There are certain provisions within the Domestic Violence Act that I have not seen applied. And one is compensation. And, you know, being a public interest lawyer previously, I've tried as best as possible, and these are just some of the challenges I faced in trying to test the legislation to ensure that we are, you know, getting, you know, as much bang for our buck, basically, to ensure that we are getting compensation for personal injury, for damage to property, and other issues related to domestic violence. And so we don't actually see this happening. And unfortunately, you know, trying to seek out willing plaintiffs is definitely a challenge. And I've experienced that myself. We might rock up to court, we'll get a domestic violence restraining order. As soon as the order becomes permanent or final, that's it. They don't want to go any further. They would like to put everything behind them. They don't want to think about ever having to go back to court to basically re-traumatize themselves and go through having to recount what happened to them, their experience. But that is an aspect that is not being utilized or not being explored, and that is compensation. And it's right there in our Domestic Violence Act, but I don't see a lot of lawyers using that, right? Testing the law. So that's another aspect that I also wanted to bring up. We have made a lot of gains over the past 3 decades, I would say, in terms of getting rid of the corroboration rule, past sexual history, proof of resistance, all of these issues. But the one aspect I think we could do to kind of strengthen the penalties and the sentencing around sexual violence is grooming. And that is one aspect that I think needs to be explored. Thank you, Kate.
Thank you very much, Lily. Can I turn to you now and your experience working with women's organisations and looking at law reform and work facilitating the access to justice? Thank you. Asmita, can you hear me?
Hi, are you able to hear me, Kate? Thank you so much for having me, and I shall try to keep to time. Today, what I'm going to do is draw on my experience, 2 experiences. The first one is working on the IGLO paper that Ria had already mentioned about access to justice programming in fragile context. And the second one is my experience with the Lawyers Collective, that's the national level NGO in India. And we campaigned for a law on domestic violence, India's first civil law on domestic violence. And this law was prepared through a process of consultation with women's rights organizations from across the country. So given the incredible breadth of the country and the diversity it has, this was quite a challenge, and it took us a good decade to get the law enacted. So I want to draw on these 2 experiences. And once that law was passed, we also did a monitoring of the law to see how the law was working. In this session, as I understand, we're supposed to be looking at the pressing needs of the survivors from our experiences. And here I want to talk about 3 specific things. The first one is to examine the legal framework as it exists and to see whether the framework is gender just. In India, and I'm sure this is the case in many other countries in the world, women continue to be in abusive or violent situations because of other discriminatory laws that exist, whether it is in relation to access to matrimonial property or other property rights, custody rights in the context of domestic violence, or in cases of sexual harassment due to unfair labor laws or job security concerns. So if we want to really make prevention and protection of women from domestic violence or any other forms of violence a reality, then the entire legal justice system has to be looked at, and gender justice laws and gender often guarantees of equality under the Constitution have to be given effect to in legislation. So I think it's one main thing. The second, in the context of examining the framework, whether we like it or not, a majority of survivors access the informal justice systems. Now, informal justice systems can be various kinds. It could be religious, it could be customary, it could be a whole, I mean, it's quite a wide and varied system over there. The question, so, for the longest time, as a lawyer, we did not want to engage with the informal justice system at all. And we said that anything which has to do with violence cannot go to the informal justice system. But I think there is an acknowledgement that things are changing. And given that women do access these systems, the question is, are these systems in compliance with basic human rights guarantees of equality? And are there referral pathways by which a woman can actually cross over from informal justice systems to the formal justice system? And finally, the question is, are the jurisdictions of formal and informal justice systems quite clearly delineated? For instance, one quite obvious thing is that you cannot have a criminal matter being tried in an informal justice setting. Is that something, is that harmonization of the formal and informal justice system, does that exist? And I think that is something which is extremely important, given that most women do go to the informal justice system. So that is in terms of whether the legal framework is adequate. The second issue I would like to highlight is, are women able to access the law? There are multiple marginalizations faced, especially on basis of caste, class, rural or geographical inaccessibility. These are all issues that women face. So how do women actually get to the formal system? And that is something we need to pay attention to. And here I think I would like to highlight the role of women's rights organizations and community-based organizations. They have played an incredible role, and one of the reasons why they've been able to play this role is because they are based in the community itself. Like when violence happens, usually it happens at night. You may think of going to the police station, but you're more likely to go to the organization which is closest to you. And that will be the women's rights organization within that, either the slum or the rural area, in a rural area, a collective. So here, and I think when COVID happened, the role of the women's rights organizations, the role of the grassroots women's organizations was really brought to the fore. And I think there are so many examples of incredibly creative and innovative practices that these organizations started doing to make sure that women are at least informed of their rights, at least are rescued from situations of violence, have custody of their children. And I think women's rights organizations have played a very important part of it. Now here I want to kind of touch upon something a little more tricky, which is, how do you learn from women's rights organizations? How do you institutionalize the practices of women's rights organizations? Unfortunately, and I think this has been acknowledged even by international bodies, that there is a certain level of growing authoritarianism, militarization, and fundamentalism that we are witnessing across Asia for sure. And what is happening because of that is that there's a shrinking space for women's organizations to work. Added to which, funds for women's organizations are also shrinking. I think of the billions of dollars which are promised for gender work, a very small portion, I think it's about 1% of that entire corpus of funds that actually reaches autonomous women's organizations. And I think that is an issue. And it is a pity because these autonomous women's rights organizations have often been the incubators of extremely promising practices which have informed law reform. So whether it is the Lawyers Collective in India or whether it is the Fiji Women's Association, their practices have informed how the laws have been formulated. And so that is one aspect of it. The second aspect of it is that how do you recognize women's rights work, women's rights organizations, without diluting state accountability? Now, you can't expect women's rights organizations to deliver a service which is the government's duty to provide. So how do you, and so what is the level of recognition that you provide the women's rights organizations or the work that is being done, incredible work that is being done by grassroots organizations? In India, we did try to put in place a mechanism. So the Domestic Violence Act that India has got 3 ways of recognizing the work of women's rights. First of all, we have the concept of a protection officer. The idea of the protection officer came from the casework that was done by women's organizations, where you're looking at issues of accompaniment, of helping women gather evidence, helping the courts access that evidence. So appointing a protection officer, so that was a way of institutionalizing the practice of women's rights. The second is to give a recognition to service providers who are within the community. So these are NGOs who are providing medical services, counseling services, shelter home services. But registration means that you acknowledge the work that they are doing to provide them protection, but you're not binding them to be duty bound to provide the protection. And finally, we had another form of recognition, which was notification of medical facilities and shelter homes, especially government ones. And once a facility was notified, they could not deny services to survivors of violence approaching them. So I'm just kind of giving you some examples of how the work of women's rights organizations and grassroots workers can possibly be institutionalized. So that is my second point of facilitating access. And I will come to the last point, which is you may have a very good law. And I think my colleague in Fiji quite correctly pointed out that no law works because the legal proceedings are just so long. Even getting a protection order the law says that you should have these protection orders and residence orders, etc., being passed within 60 days, but it never happens. And you have to wait for a very long time for these laws to come. But the point of a situation of violence is that you need immediate relief. So the question is, how do you get that? And I think the emphasis over here is on to what extent are you able to get ad interim relief. So even if the proceedings take a very long time, are you able to get those interim reliefs? And I know this seems to be a very small point, but it is something which really makes a difference between life and death. So ad interim relief. And one more thing that in India, at least the activists have been looking at, is that, there are contexts of poverty. Women do not have economic, necessarily have earnings, etc., to sustain themselves during the litigation processes. So is it, and also, like getting alimony and maintenance, getting it from the other party is very, very difficult. So can we think of some innovative practices such as court funds, alimony funds, which the court can provide immediate economic compensation immediately or economic relief immediately, and then use their own processes to get it back from the perpetrator. But at least the woman's immediate needs are taken care of. So these are the 3 very quick points that I wanted to make. And I do have some points for the rest of the questions that you've posed. So thank you very much.
Thank you very much, Smita. I'm sort of conscious of the time and we're covering some of the issues in those broader questions as well, but we'll see how we go. Barbara, can I turn to you now? Thank you.
Yes, thank you. Good afternoon, everyone. Thank you so much for giving us the opportunity to share our experience and to learn a lot throughout only one day. So the challenge and the experience which we face in Timor-Leste is quite similar to the ones faced in Fiji. But also we would like to add to some of specific lessons learned, some of the specific issues which we have been facing here. So, of course, that always our experience is shaped by where we work, our background, and also the path we take towards our vision. While progress has been made in Timor-Leste with a domestic violence law approved in 2010, we are still quite well behind in relation to recognition of victims' rights. In this reality, the fact is sometimes we experience expected challenge. Small, we get small and large wins, but overall, we are also still meeting strong resistance from court actors when we try to demand the rights of the victims. Our organization is called JUS, Jurídico Social, which like a direct translation would be Social Legal Consulting. And we are social enterprise in Timor-Leste. And we provide like consulting service in the area of human rights, gender equality, child protection. And with our consulting service, we can then fund our pro bono legal representation. We do strategic litigation, and because of the high prevalence of gender-based violence in our country, our legal representation has mostly focused on gender-based and sexual violence. Just to give some illustrations, some of the cases which we have been working on. For example, we have worked in a case, male child was victim of sexual abuse, and initially no indictment was filed because the forensic medical examination showed no sign of abuse. We also have represented victims of domestic violence in cases where the husbands or the partners, they are powerful men in our community because they have high economic status or they are like in public positions. We also represent victims of sexual abuse committed by local healers under the fraudulent disguise of medical intervention. And one large case which we have supported is the representation of victims of systemic child sexual abuse committed in a child care institution by members of Catholic Church in the most Catholic country in the world. So you can expect some of the challenges which we have faced. And very interesting, we also make an effort to represent women who are accused of crimes themselves. And they are often given harsher sentence just because they are women and because by being an offender, you know, they are kind of breaking away from the expected role of being a mother role in our society. So with this experience, like I think we were able to identify a number of pressing issues which we would like to share with you today. One big issue which I know that has been dealt with is how do you do to ensure that judges and prosecutors know that GBV case is treatment? How can you promote a view that understands that effective equality before the law, you know, a basic principle of
Angela, I don't know if you're with us, but I think Barbara might have been frozen. Barbara, you just froze for a little while.
Hello?
Okay, we can hear you now. Thank you.
Ah, okay, sorry.
We can hear you now.
Thank you.
Angela,
Judge.
We'll pause her video.
Problems with the connection. Right, Barbara, let's try again. I hope I can hear you. No?
We switched off her video so that to help her audio.
Barbara, can you
Barbara?
hear? Well, what I might do while Barbara's connecting her line, Henry, can I bring you in at this point just to talk about some of the work that you're doing for the bank in Nepal and in Fiji?
Sure, thanks, Kate. Yeah, it's a privilege, of course, to be among this illustrious panel who are doing such important work. At ADB, our law reform work in relation to gender-based violence is principally focused on judges and training them to better understand the ways in which gender-based violence cases and related cases can affect the rights and well-being of victims, and doing what we can to improve survivors' opportunities for natural justice and procedural fairness against circumstances that are often quite challenging due to many of the circumstances that have been described already. I think one of our other contributions, increasingly looking to the future, would be to build on the sort of work that Nalini does and also Kate as well, in bringing empirical analysis into the question of how do we treat cases of gender violence. So that's something that I think we'll be getting more involved in into the future. Thanks, Kate.
Thank you, Henry. I'm not sure if Barbara's back to join us, but let's hope.
Yeah.
Barbara,
I am
can you
here.
hear us? All right, thank you. So I'm sorry that you were interrupted. So I think we were at that point where you're talking about some of the specific work that you've been doing and starting to talk about sort of some strategic work. So can I ask you to,
Yes.
from where you were? Thank you.
Sorry about that. Crazy things happen in this country. We tested and I have been online the whole morning, and then at my time to talk, it comes down. But that's how we can just, dust it off. So we were talking like a little bit, reflecting on all these issues which play and which were basically at interplay in determining our experience, representing victims in Timor-Leste. So I was referring to the whole understanding that equality before the law effectively requires differentiation and positive actions. And that understanding here is still at the early stages. Also, similar to Fiji, we are testing the waters, so how do we do to carve our way into promoting legal practice and judicial interpretation on the role and powers of the victims when there was very little before. Just to give you an example, like of the challenge which we are facing and the experience, like things which happen with our lawyers is, and what we would do in the situation where actually during a trial, we represented the victims of sexual abuse, and the judge decides to close the hearing so public cannot attend, but observation, at the same time, the judge orders the lawyers of the victims to leave the courtroom because the hearing is closed. And what do you do in those situations? How can you do your work? And also some of the issues which we face is actually we submit the petitions, and sometimes there is a simple, clear silence. They are never answers, they are ignored. And not because they are purposely ignoring, it's the fact that no one has done that before. Like the court is a little bit clueless what should happen in those cases. Because similar to Fiji, many of the legal framework has not been fully explored. And one other issue which we consider very relevant in our experience is how do we balance the legal aspects of a case, our kind of fight against the system, and the aspirations and desires of the victims. And in Timor-Leste, because the way that the society works, our community, how can, like, we try to support the victims through agency and empowerment, but while we are doing that, we know that most probably, as a consequence of their empowerment, they will be ostracized from their own community. So how do you work in that kind of environment, and how do you play your role? So in reflecting for this conference, actually, we at JUICE, we came up with a total of 6 lessons learned, which we think that will take 2 minutes to share with you all. The first lesson learned from our experience is we need to be ready to stand up and question judicial and prosecutorial practice. But that has to be done with very strong legal arguments and strictly within applicable legal procedures. We also another lesson learned that we can only be successful if we promote collective knowledge and decision making. So we do not work on one lawyer representing a victim. We have a collective effort, and where we discuss different legal minds, different perspectives, different background experience. We discuss the potential strategies which we want to take and make collective decisions on the path to take. And all of that on top in our lessons learned needs to be informed by social and psychological aspects, which can always play and influence the outcome. Another lessons learned, which we can draw, is expect the worst. Expect negative results from the court and the just settle to our request. Either they are not answered or they are negative. Even when it's very clear the law that we have the right to request those. We need always to have a plan B and a plan C, and even consider the possibility of settling for much less than what would be the ideal. You know, many people question sometimes, you know, like, oh, it could have been better. And like, yes, but for our reality, it has been a lot already. Let's be realistic and let's, you know, settle sometimes for something which is less than ideal. Another lesson learned on the hard way, we need to accept we will make enemies along the way due to the current stats of the society and the fact that violence against women is kind of seen as a normal practice in the society. We will find enemies from court actors, local community, politicians, men in position of power, and in our experience, even from our own family members. One thing when we talk about legal representation of victims, of survivors, there is the need to have, it's not all about case strategies, legal arguments, you know, identifying, writing petitions. It requires enough energy, establishing trusted relationship with the clients. And that also comes the challenge, you know, where you draw the line, you need to establish a trusted, close, but ethically professional relationship. But in a small country like Timor, where the fabric of society is based on personal relationship, it is an effort which we have to make, both to establish the relationship and to draw the lines within this professional relationship. And of course, you know, our last lesson, which we actually try to remember ourselves every day, and we say in Tetum, la belle rende, which in English would be never give up. And we need to be ready also for the long run, you know, something which appears on paper to be a legal, straightforward case and something very quick. In Timor-Leste sometimes can turn into a long-term involvement, which you need to be ready to take on board. Thank you, Kate. Apologies for the technical problems.
That's Thank you, Barbara. I hope that you can hear us. Now I'm looking at the time, and Christina is probably there, and I suspect that we've only got a few more minutes in the time that we've got, but I feel so many issues have been raised in the session. What's come out of the discussion, I think, is the courage that advocates must have to support women accessing the judicial system, the importance of the integrated support, the importance of lawyers understanding, as Barbara just said, building those relationships of trust, but also knowing how to connect into the systems. Those points about the differences between the formal and informal justice systems and how blurry the lines might be in those two systems. And as Nalini has spoken about, it's advocates understanding power, understanding patriarchal systems, and finding ways to both fight or confront that, but also work within those systems to be able to access justice. So I wonder whether I can actually ask the panel members to just go to our final topic, which we wanted to talk about looking forward. And could I ask you each briefly to say, what do you think now needs to happen so that we can achieve better access to justice for victim survivors? So, now, and I can see Christina there. Can you bear with me while I just ask the panel members for some observations on this important topic?
Of course, it's very important. So the panelists can go ahead. Thank you.
So I might start with Barbara, just in case we have any more difficulties with the connection to Timor-Leste. So Barbara, if you can still hear us. I think you did say never give up, and that's a very important message. Anything that you think we need to think about looking forward to achieve?
Forward. So I will be very brief, and it's one phrase, is accept, recognize the victim not as an object of the system, but as part of the system, where there is this symbiotic relationship between the public authorities and the victims and those representing them.
Thank you, Barbara. Asmita, I know there's lots of things that we were going to talk about, but just on this one point.
Three very quick suggestions. I think we need to increase spaces for engagement with civil society and women's rights organizations, those who bear the knowledge and the practices of how to, how to support women in the most comprehensive way possible. At the grassroots level, they won't think of, civil law, criminal law, health, etc. It's a very comprehensive way of working. So to provide spaces for engagements with civil society, I think that is one point. The second is that there has to be an investment into the justice processes to make access to justice a reality. And in here, because even now, the criminal justice, of course, the state takes over, but when it comes to civil justice, it's always petitioner based. So if we need to have supportive institutions and mechanisms that actually help women and do this bridging between the multiple stakeholders and provide an integrated form of response. And finally, I think, again, COVID, there are many horrible things that happened, but it also did show up some innovative practices and the question of bringing justice closer to the home. So whether it is kind of exploring a little more practices such as mobile legal aid clinics or mobile services, legal services to women who are not able to very effectively come to the justice system. So these would be my three suggestions.
Thank you very much. I think that echoes some comments about access to justice in the maritime areas in Fiji and that importance of going to where women are. So that's, thank you. Henry, can I ask you for your comments on this final topic?
Apologies, I'm joining from Dhaka and my internet just failed, and I missed the question, but I can talk to the what I can talk to is the a few of, I think, the sort of lessons learned from you know, our experience in how to better integrate support for survivors. And I think one of the key lessons is the training of police, practitioners and judiciary on sensitivity to survivors of gender-based violence. And then the next is that we're actually already aware from some leading cases and reforms that have taken place all around the region of what can work. So the next job is to start working together as civil society advocates and even institutions like Adb to roll out what has worked elsewhere in culturally sensitive ways that work for the local environment. The biggest challenge, I think, perhaps, comes to men, the men in our societies. We've heard a lot about the concept of men's sexual entitlement, and convincing anybody that something they see as an entitlement is not an entitlement at all can really be no easy task. And we do need to challenge this one, or we're going to face massive problems, because if this is an issue throughout society, then it's an issue in the judiciary and the police as well. We can probably assume to at least some extent. So we need to approach this creatively. Culturally sensitive education programs that engage men in ways that they've been shown to respond to, I think, has to be a priority. And this, in my opinion, is something that will vary between societies. And I think we need to know much more about that in general, and how we can achieve better results in that regard. So that I would encourage as an area for further research. Thanks very much.
Thank you very much. Lily, can I turn to you?
Hi. So I'm just going to add to what Henry had mentioned earlier, and that is just ensuring that there's building awareness and capacity for advocates in trauma-informed spaces, and ensuring that particularly, you know, the first point of contact, which is with police, are increasingly being trained to be more trauma-informed, and, you know, that they are partnering particularly with women's organizations such as the Fiji Women's Crisis Center, the Fiji Women's Rights Movement, and other counseling services to be able to provide that kind of awareness and gender sensitivity. I think it's really important. One other aspect I wanted to also mention is just ensuring that, you know, one of the partners that we often leave out, you have civil societies, you have national agencies, state agencies, we tend to forget the private sector as well. And so I think it's important to involve the private sector, particularly when you look at labor force participation for female workers being 38.2%. And those workers being able to access support services within their workplaces. And I see that, you know, over COVID, during the lockdowns, this exacerbated women's situations, particularly survivors, who often see the workplace as a haven. And so here they were trapped with the perpetrators at home. And this is where I'm going to put on my development hat and say that IFC, particularly with the private sector, has worked to develop a Respectful Workplaces program where they have put together policies, procedures in place to assist workers who are affected by domestic and sexual violence, which can also lead to access of legal services, access from police protection, safe homes and shelters, and also the justice system. So I think it's important to also integrate, that integration approach should also involve the private sector as well. Thank you.
Thank you. Nalini.
Thanks, Kate. I think in the final comments, I'd say I wholeheartedly support what Ashmita has said around recognizing the work of the women's rights movement and organizations, and acknowledge the work that we do, and also be receptive to the work we do, fund the work we do, fund the researchers we do, and act on the research recommendations, because we are not creating more work or telling. Our recommendations don't come from a sort of a place which is addressing all the various issues that we talked about, and the formal justice sector. Who is it for? Why do we have all of these processes? Why do we continuously work on making sure that those it is broken down and made accessible to those that need it? So then we also then have to respond to the question of then why do those that seek the services, the victim survivors, why do they feel often more abused and traumatized when they come out of the system? These are all the reasons why we put up the recommendations. As my colleague said, more education, and unlearning some of the things that we have inherently ingrained in ourselves that is stemming off from patriarchal attitudes, because that does not help anyone that is stepping into, after having survived such violence, to seek the justice. For the judiciary, the police, I think all the formal justice sector agencies, must look at their budgets, and ensure that their budgets are gender responsive, and they have within their budgets funds to fix their infrastructure. It's not acceptable in this day and age to have court houses that don't have creches for children. That's a must. You cannot have excuses for not having technology, that would safeguard children from sitting across from those that have abused them. So all of this can be built into their budgets. It's requiring a little bit of effort and understanding how to do that. But, in this day and time, that is inexcusable. The national processes that are ongoing, the national action plan on the prevention of violence against women and girls, we have the ways in which we are trying to work with government through another process that is looking at, transforming the ministries and to make them more gender responsive. There's, all of this good work that is going on, and everyone needs to have a hand in it to make it meaningful. And finally, data. We need that, and the more desegregated the data, the better it is for analysis. Location, age, every other parameter that we can, because this all goes to improving the recommendations and making things better. Thank you.
Thank you, Nelly. Thank you, Christina, for indulging me with the extra time. This is such an important panel and such important issues. I feel that we could continue these discussions for days, but I hope we can reflect on the conversation today about areas for improvement, but also our shared experience, even in different jurisdictions and different experiences. There are shared experience of women and the difficulties that they sometimes experience in accessing justice. So could I ask everybody to thank our panelists today for their wisdom, their compassion, the kindness and speaking from the heart that they've shared with us today about these important issues. Thank you very much. Thank you, Christina.
Thank you so much, Kate, and our excellent panelists. I mean, I think it was great that we had that, that last question, because it really summed up, what the needs are and what the challenges and just importance of having the investment in solving this issue or working together. So I think it sort of like leads into our last concluding session, which we already had with this session. So I think, I'm hoping technology will work and we could get a few takeaways from the other sessions, but I'm not sure if Robin or Zari are on. Robin or Zari, if they're not on, I think we can conclude today's conference. It's been an extremely valuable conference, and we really appreciate you showing up for all your dedication. And it was great to get all the different stakeholders together virtually and in Fiji. So we really appreciate just your dedication, your tireless efforts, and we hope that we can contribute to this effort. We know that different donors and partners go, but we have this technical assistance available with the ADB in working and in conjunction with other partners, as well as all the key stakeholders that are really been working on this for years and years. So we really look forward to working with all of you, and thank you so much for your valuable time today and for all your excellent contributions. So we will make some of the conference sessions and materials available, and you'll get a post-conference booklet with everyone's contributions, case law that judges brought up, and we will also distribute some of the video clips. So again, thank you so much for attending today. Really appreciate it. Thank you.